Loud. That is roaringly loud. Okay. All right. And so we should be actually hearing Justice Thomas speak today. Wow, Brandy, hey. Thank you, Brandy. Let's see how I can do this. Oh, yes. Still though. Hmm. You know.
On these and many other issues which we can barely glimpse on the horizon, even full-time professors of constitutional law do not have a completely settled view. When all is said and done, Mr. Chairman and members of the committee, I believe that the Senate should vote on Clarence Thomas's nomination not based on his position on any one or two or three issues, but first on his ability to reason clearly, to reason fairly, and to reason wisely, as reflected in his answers to your questions which will be propounded before this committee. And second, on his character, as indicated by his background, his values, his life experience, and the judgment of those who know him best. Mr. Chairman, I hope that this committee and the Senate will take the long view of this nomination and the long view of the role that this 43-year-old nominee will play on the Supreme Court for years to come if he is confirmed. Those who know Clarence Thomas best, and I've talked to many of them, make a powerful case as to his values, his legal and judicial abilities, his integrity, and his determination. I'm certain that some will judge Clarence Thomas by trying to pin him down on some fixed point of the ideological spectrum. I hope, however, that the majority of this committee and the majority of the United States Senate will vote on our perception of his character, his judicial abilities, his independence, and most importantly, his willingness to learn and develop from experience and from reflection. Mr. Chairman, I introduce Clarence Thomas with pride, in part because he was born in Georgia, spent his childhood in Georgia, graduated from high school in Georgia, practiced law in Georgia, and has family and many friends in Georgia. Mr. Chairman and members of the committee, Clarence Thomas has climbed many jagged mountains on the road from Pinpoint, Georgia, to the Senate Judiciary Committee. I believe that if he is confirmed, Judge Thomas will remember his own climb and will always insist on fairness and equal justice under law for those who are still climbing. Mr. Chairman, I'm proud to introduce to this committee Judge Clarence Thomas, a native of the state of Georgia.
Thank you very much, Senator Nunn. Now, Senator Fowler.
Mr. Chairman, I certainly join in the pride of my senior colleague that a Georgian has been nominated for the highest judicial office in the land. In fact, I cannot think of a time of similar pride, both for myself and for Georgians, except for the nomination of Georgian Martin Luther King, Jr. for the Nobel Peace Prize. As Senator Nunn has said, we have had visits and trips, and there is remarkable enthusiasm, not the least because Judge Thomas has already succeeded not only in putting Pinpoint, Georgia on the map, but so swell their breasts with pride that they are seeking to annex Savannah and Hinesville and half of the Georgia coast. The second reason, though, and far more important in joining in this introduction, is that it means that political speculation about this nominee should be over. It is now through your offices, the members of the Senate Judiciary Committee, that we can begin the thorough examination of the nominee and his beliefs that the Constitution requires of us. Judge Thomas has already shown himself to be a man who has broken many molds and defied many labels. It seems to me that we have no less an obligation, a constitutional obligation, to not submit ourselves to easy categorization as we fulfill our constitutional obligations, which I believe Judge Thomas would agree with were he in your position. I know that you, the members of the committee, all join me in putting some of the unsavory political campaigning that has gone on behind us. that has been at the least a rude distraction both to the constitutional process and to Judge Thomas's nomination. Now we can get on to the real responsibilities of the Senate confirmation process. Judge Thomas is perfectly able to express himself, present his case. I know he will do it, and the American people deserve the thorough examination of those views before a decision is made.
Thank you very much, gentlemen. I know you have other obligations. We appreciate your taking the time to come and introduce your Georgia's native son. Now we will hear from the senators who are going to introduce Virginia's adopted son. We begin, as we have a wont to do here in the Senate, in order of seniority, and begin with the distinguished senior senator from the state of Virginia, the Commonwealth of Virginia, Senator Warner.
Thank you,
Warner.
Mr. Chairman and members of the committee. Like our Georgia colleagues, Senator Robb and I likewise consider it a privilege to appear here today on behalf of Judge Thomas and in a way on behalf of the constituents we represent in the Commonwealth of Virginia. Mr. Chairman, I would like to have my statement inserted in the record in full. I want to be brief.
Without objection, your entire statement will be placed in the record
Brief,
as
such that we can move along with these proceedings. But I wish to acknowledge that my personal preparation for this hearing has been a very valuable learning experience for me. I traveled. It's not over for you yet, Mr. Chairman. I traveled throughout my state, finishing yesterday the last of some 14 meetings. Most of these meetings dominated by minority individuals, minority background. And I listened and learned very carefully. I say to my colleagues, it was a profitable experience. This procedure we're undertaking now, mandated by the Constitution under the Advise and Consent Clause, will, I hope, end up in two ways. And first I say to you, my friend Judge Thomas, most respectfully, I hope that it's a learning experience for you and that you emerge from this a stronger, a wiser, and a more compassionate person. And secondly, that these hearings and the floor debate and the final vote will be perceived by citizens across our land as being done fairly and objectively, and that will constitute a record and a support for this fine American to go forward and take on his responsibility with a greater unity across our country. The hearing has the opportunity to dispel a number of the concerns that were voiced to me by conscientious individuals, but we have that opportunity as senators in this free and deliberative process to dispel those concerns. This is a very interesting nomination in the sense that the United States Senate has already acted in confirming Judge Thomas as a Federal Circuit Court judge. We rendered our judgment, and therefore we are being examined. And to the extent that some of us may wish to re-examine that, I say to you most respectfully, you have a very heavy, if not the highest, of burdens of proof. The burden of proof has shifted to the Senate since it has already spoken on behalf of the credentials of this man. It's for those reasons that, again, I conclude by saying that I hope these Senate proceedings will be perceived and accepted as fair and objective, and at the final conclusion, which I hope will be confirmation, will be in the best interest of our United States. I thank you.
Thank you very much, Senator. Senator Robb, welcome.
Thank you, Mr. Chairman, Senator Thurman, other members of the Judiciary Committee. As a Virginian, Senator Warner and I are frequently extended the courtesy of introducing for Senate confirmation residents of our state that the President has nominated to high-level positions in the federal government. notwithstanding the fact that in most cases they have burnished their credentials while bearing true faith and allegiance to a political party other than the one that at least I happen to represent. In that capacity, I was pleased to introduce Judge Thomas when he was nominated to his current judgeship with the U.S. Court of Appeals for the District of Columbia Circuit. Recognizing the importance of a lifetime appointment to the highest court in our land, however, and the prospect that if confirmed Associate Justice of the Supreme Court at his age, he could well serve for 30 years or more, I don't suggest that any prior examination of his credentials ought to substitute for the thorough examination you are about to begin, or that our prior vote to confirm Judge Thomas ought to obligate us necessarily to confirm Justice Thomas. Therefore, like most of our Senate colleagues, I'm going to withhold final judgment until these confirmation hearings have been completed and your committee has acted. I would be less than candid, though, if I didn't observe at the outset that I have had two very good meetings in my office with Judge Thomas, one for each of his nominations, and I am very much impressed with the way he has dealt with the challenges that he has faced. I am impressed with his life story and the way he has persevered against the odds. I am impressed by the way he has thought about the way society works and doesn't work, and I am impressed by his sense of conviction about the ideas and principles in which he believes. I care deeply about the issues most often cited by those individuals and organizations that have announced their opposition to Judge Thomas. And because I am more often aligned with them than against them, I simply ask that they join me in withholding final judgment until they have actually heard Judge Thomas respond to direct questions about those issues which concern all of us. I believe, based on my own conversations with him, that he'll respond to many of those questions and concerns in ways that will be far more reassuring than inferences that have been drawn solely from fragmented comments and speeches where the questions have not been squarely joined. In short, I find Judge Thomas more difficult to stereotype than his public image might suggest, and I believe almost everyone will discover a few surprises during the confirmation process. Mr. Chairman, you have an important responsibility to fulfill, and I wish you well.
Thank you very much, gentlemen. Now, we'll move west of the Mississippi, and the state in which our distinguished nominee has worked and has friends, and one of his friends is the junior senator from the state of Missouri, Senator Bond. Senator Bond, welcome, and we're anxious to hear what you have to say. Excuse me.
Thank you very much, Mr. Chairman, members of the committee. It is a great honor and a pleasure for me to come before this committee today to join in the multifaceted presentation of Judge Clarence Thomas, the President's nominee for Associate Justice of the United States Supreme Court. Coming third, we from Missouri have to make a major effort to claim him for the state of Missouri, but we do so with a great deal of pride. I had the real pleasure first of meeting Judge Thomas when we both worked in Jefferson City, Missouri in the early 1970s. Both of us began our career in state government as Assistant Attorney General under Jack Danforth. It was an exciting and intellectually challenging place for a young lawyer to work. The outstanding caliber of the other people that Jack Danforth brought to that office is best illustrated by the jobs that some of them now hold. Federal judges, chairman of the FCC, and we hope soon a Supreme Court justice. Even among a cast of stars like that, Clarence Thomas shone as a lawyer. He was not content simply to move cases through the office, but instead worked to use his position to accomplish change and to improve the lives of people in our state. His legal work and his intellect were noticed not just by Jack Danforth, but by many others as well. And when Jack was elected to the Senate in 1976, Clarence Thomas came to Washington, applied his skills to a series of jobs ranging from corporate lawyer to the chairman of the Equal Employment Opportunity Commission. giving him the opportunity to learn firsthand about a wider range of legal areas than most recent nominees to the court. Say, Mr. Chairman, that if you look at the group of people who know Clarence Thomas best, you will find his most ardent supporters. I only hope that those who do not know him as well as we do may have the opportunity during the course of these hearings to gain the knowledge and the respect that we have. Though his skills as a lawyer and a judge are obvious, they are not, in my view, the only reason that this committee should vote to approve Judge Thomas's nomination. Just as important is his compassion and understanding of the impact that the Supreme Court has on the lives of average Americans. We're all familiar with Judge Thomas's background, as outlined by the distinguished colleague from Georgia. It is an inspiring story. There is no doubt that he can be proud of his achievements. But it's also important to focus on his continuing efforts throughout his life to live up to the values and principles that his grandfather instilled in him, which I know were strengthened by the many years he spent living in Missouri. The strength of character is every bit as important as his professional qualifications, and I urge you to consider it as you proceed with these hearings. Mr. Chairman, there have been many accusations and straw men raised over the course of the past few months. Unfortunately, that has become a part of the nomination process. Though we cannot stop people from voicing their opinion or attacking a nominee or even members of the committee, unfair or groundless as those attacks may be, we can disregard those charges and focus on the important details, the nominee's fitness for the job. I urge the members of the committee to do just that. I know that when they do, they will find Judge Thomas to be well qualified to serve as the newest member of the United States Supreme Court.
Thank you very much, Senator. I might add, Judge Thomas, I had the occasion to spend about 7 or 8 days with the junior senator from Missouri in the month of August. And when he was not lobbying me on matters relating to the North Slope and others, he was lobbying me with regard to you. You were probably the only Supreme Court justice who's ever been, or nominee, who's ever been discussed on the North Slope of Alaska, in the middle of nowhere. So you should be grateful to the man who I am. It's the only reason I was happy the trip was over. But having said that, now let me ask the senior senator from the state of Missouri, a man who is, a number of precedents are being set in these hearings. Everyone's talking about the precedents being set, Judge Thomas. I don't know whether or not we should call this the Rudman precedent or not, but you have one of the strongest and most ardent supporters I suspect you have anywhere, including your mother and your wife and your son and your sister, in the person of a senior senator from Missouri. We're all supposed to be limited to 10 minutes. I want you to know at the outset I have no illusion that this is going to be a 10-minute introduction. And I will, for my respect for our colleague from the state of Missouri, I will, whatever the clock is, do what, as you'll remember, Senator, the former chairman of this committee, Senator Eastland, used to do. He'd say we have to end this meeting at 2 o'clock. Or we're not able to meet beyond that time. And some would say, I notice it's 2 o'clock, Mr. Chairman. He'd turn around, open up the face of the clock, and turn the clock back and say, it doesn't look like 2 to me. So we'll invoke the rule of the former chairman of this committee, and Jack, try to keep it under an hour if you can.
Mr. Chairman, thank you very much. I'm sorry that the North Slope gambit didn't occur to me during this process.
Well, I assumed you put your junior colleague up to it, but...
Mr. Chairman, members of the committee, other than the nominee himself, I know Clarence Thomas better than anyone who will appear before this committee. I hired him 17 years ago when he was a law student. He worked for me twice as an assistant state attorney general and as a legislative assistant, and we have kept in touch since he left my office. His life story is public knowledge, and I will not review it for you. Instead, this will be a personal testimony about the Clarence Thomas I know and a reflection on the case that is being made by various groups that oppose his confirmation. Let me begin with the most fundamental points. Clarence Thomas is intelligent, hardworking, honest, and fair. Because these are the minimum qualifications we expect of a nominee for any position, I will not dwell on them. It's enough to assure the committee on the basis of personal knowledge that Clarence Thomas possesses each of these requisites to serve on the Supreme Court. As the ABA will testify, he is certainly qualified for the job. But he has more than these fundamentals. The Clarence Thomas I know has special qualities which convince me that he is more than the average nominee. He would be an extraordinary justice on the Supreme Court. What are these special qualities? First, Clarence Thomas is his own person. President Bush had it absolutely right when he called him fiercely independent. This quality struck me when I first interviewed him in the faculty lounge at Yale Law School. Clarence made it clear that he was his own person to be judged on his own merits. He was not to be the special case given special treatment, and he was not to be given special work within my office. He was uniquely Clarence Thomas, and his goal was to be the best Clarence Thomas he could possibly be. He has reached that goal, and that to me is his most striking attribute. Repeatedly he has said that as a judge he has no personal agenda and that he will call them as he sees them. That pledge is a function of his independence, and it's completely consistent with the Clarence Thomas I know. It's consistent with the young Assistant Attorney General who, to my political dismay, insisted that my constituents had no legal right to keep their low-numbered license plates. It's consistent with the chairman of the EEOC, who excoriated his own administration for favoring tax-exempt status for a racially exclusive college and for opposing extension of the Voting Rights Act. I have no doubt whatever in giving the committee this assurance. Just as Clarence Thomas will resist any effort to impinge on his independence by seeking commitments on how he will decide cases before the court, so he will never become a sure vote for any group of justices on the court. For 2 months, I have noted with wonder the certainty of various interest groups as they have predicted how the nominee would vote on an array of issues. They don't know Clarence Thomas. I do. I cannot predict how he would vote on any issue. He is his own person. That is my first point. Second, he laughs. To some, this may seem a trivial matter. To me, it's important, because laughter is the antidote to that dread disease, federalitis. The obvious strategy of interest groups trying to defeat a Supreme Court nominee is to suggest that there is something weird about the individual. I concede that there is something weird about Clarence Thomas. It's his laugh. It is the loudest laugh I have ever heard. It comes from deep inside and it shakes his body. And here is something at least as weird in this most uptight of cities. The object of his laughter is most often himself. Third, he is serious, deeply serious, in his commitment to make a contribution with his life. I'll never forget visiting with Clarence after he had been nominated for a second term at the EEOC. I pressed him on why he would accept a second term. It's a thankless job, one that when done well makes everyone mad. It's a career blind alley. He answered simply, "I haven't yet finished the job." I pondered that statement many times over the past 5 years. Undoubtedly, he meant that he had not yet finished the job of transforming the EEOC from the administrative basket case he inherited to the first-rate agency it is today. But I think he meant more than that. I think he meant that the discrimination he has known in his own life is still too much with us. There is so much more to do if we are to end it. This is the seriousness of Clarence Thomas. It's not anger, as some have suggested. It's not a bitterness that eats away at him, but it's profound. And it forms the person he is and the justice he will become. I hope that sometime in the days Judge Thomas will be before this committee, someone will ask him, not about unenumerated rights or the Establishment Clause, but about himself. What was it like to grow up under segregation? What was it like to be there when your grandfather was humiliated before your eyes? What was it like to be laughed at by seminarians because you're black? Everyone in the Senate knows something about the legal issues before the Supreme Court. Not a single member of the Senate knows what Clarence Thomas knows about being poor and black in America. For more than 2 months, interest groups have been poring over the volume of speeches made by the nominee, looking for the word here or phrase there that could be used against him. I hope all of us will read some of his speeches in their entirety. They are eloquent statements of his deep commitment to justice in America. It's better to read the whole speech, but if we're piecing together sayings, here's my compendium of the words of Clarence Thomas. He said, and these are his words, "What is more immoral than the enslavement of an entire race? What is more immoral than the vicious cancer of racial discrimination? What is more immoral than the fabrication of a legal and political system which excludes, demeans, and degrades an entire race?" He said, "Discrimination holds out a different life for those who do not happen to be the right race or the right sex. It is a world in which the haves continue to reap more dividends than the have-nots, and the powerful wield more influence than the powerless." He said, "It exists in the factories, in the plants, in the corporate boardrooms. It makes a lie of our pledge of freedom. It is the great fault that sends tremors through the bedrock of our nationhood." He said, "I never understood the logic behind the division of labor that decreed that women be restricted to certain jobs. Such waste of talent, such infringement of individual rights." He said, "Today the civil rights laws often appear to be without teeth to ensure non-discrimination." He said, "There is something less than equitable about a system that subjects an individual to stronger sanctions for breaking into a mailbox than for violating the basic civil rights of another human being." Those are the words of Clarence Thomas. Name one other member of the Supreme Court that talks like that. Name one other person who could conceivably be nominated by President Bush who talks like that. The obvious question is, why do some civil rights leaders, good people, oppose a nominee with such a strong commitment to equality? The answer lies in a major debate now taking place in America, which divides good people who share a common commitment to equal justice. With respect to the black community, William Raspberry has described the debate as follows. At issue is whether it is wiser to pursue government policies that target blacks generally, contract set-asides, affirmative action, hiring and promotion, race-based special admissions, and so on, or to fashion approaches based on specific social, educational, and economic conditions. Oversimplified, Raspberry continues, the two opposing propositions can be stated this way. 1, race-specific approaches. 2, approaches that target the conditions, joblessness, drug abuse, family dissolution, and undereducation. Before becoming a judge, while he was in the executive branch, Clarence Thomas was a leading advocate for one side of this debate. At that time, he argued that race-based preferences are not helpful to the most disadvantaged citizens, that they stigmatize and sometimes even victimize the beneficiary, and that they create destructive animosity among unfavored citizens. In their place, he advocated affirmative action based on disadvantage rather than race, with special emphasis on education and job training, coupled with strict enforcement and tough penalties in cases of specific discrimination. I do not understand why the nomination of a Supreme Court justice should be the occasion for arguing the best political strategy for advancing the cause of civil rights. Whether one strongly supports or strongly opposes race-based preferences should not trigger an attack on the person's motives or fitness to serve on the court. Nearly a third of black families are now living in poverty. Nearly a third of young black men do not have jobs. The average income of blacks is not much more than half that of whites. Against this background, we should welcome, not penalize, a diversity of opinion on solving the problem of inequality. We should welcome a diversity of opinion among blacks as well as whites. If support for race-based preferences becomes a litmus test for the Supreme Court, that test would rule out a majority of the American people and a majority of the members of the Senate as well. Mr. Chairman, throughout this process, you and all members of this committee have been characteristically considerate and fair to the nominee. I join him in thanking you for your kindness. I am convinced that, like the President, you will not judge Clarence Thomas on the basis of litmus tests. You will judge him on the basis of his ability and character and the special qualities he would bring to the court. It's a proud day in my life to present for the Supreme Court a person I know so well and believe in so strongly.
Thank you very much, Senator Danforth. And I know the nominee knows how fortunate he is to have a friend like you. While you're on your feet, Judge, we will swear you.
Can you still see the nominee, Mr. Chairman?
There's an eye. Please take
Judge, while we're just passing some time here, I just want you to know, up until a few nominees ago, this is what you would have faced the entire time of your questioning. They're all gentle souls, but they're anxious to see you, and we agreed that we would do this so they could have you sworn in. Judge Thomas, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated. Well, Judge, as Jack Danforth said, talked about what's at issue. I want to make it clear at the outset of my questioning that there's a great deal more at issue than whether or not your view on how to deal with the civil rights of Americans deviates from the view of any single group of people. I beg your pardon? So I would now like to invite you to, having been sworn, to, if you would, please introduce your family to us. We've been waiting patiently all morning, and the committee is anxious to meet them, as I'm sure everyone else is. So would you please introduce your family to us, Judge?
Thank you, Mr. Chairman. I'd like first to introduce my wife, Virginia.
Welcome, Ms. Thomas. Pleasure to have you here.
My mother, Leola Williams, my sister, Emma Mae Martin, and my son, Jamal.
Jamal, welcome. You look so much like your father that probably at a break you'd be able to come back in and sit in there and answer questions. So if he's not doing it the way you want it done, you just slide in that chair.
Also, he may not take it as a compliment if you say he looks like me.
He's young. He has a chance to grow out of it, as my father says about my sons.
I'd like to also introduce my mother and father-in-law, Donald and Marjorie Lamp, who are in the audience here.
Would you please stand, Mr. Welcome to the hearing. Thank you very much for coming. You have an opening statement, Judge?
Yes, Mr. Chairman.
Please.
Mr. Chairman, Senator Thurman, members of the committee, I am humbled and honored to have been nominated by President Bush to be an Associate Justice of the Supreme Court of the United States. I would like to thank the committee, especially you, Chairman Biden, for your extraordinary fairness throughout this process. And I would like to thank each of you and so many of your colleagues here in the Senate for taking the time to visit with me. There are not enough words to express my deep gratitude and appreciation to Senator Danforth, who gave me my first job out of Yale Law School. I have never forgotten the terms of his offer to me: more work for less pay than anyone in the country could offer. Believe me, he delivered on his promise, especially the less pay. I appreciate his wise counsel and his example over the years, and his tireless efforts on my behalf during the confirmation process. And I'd like to thank Senators Bond, Nunn, Fowler, Warner, and Robb for taking the time to introduce me today. Much has been written about my family and me over the past 10 weeks. Through all that has happened throughout our lives and through all adversity, we've grown closer, and our love for each other has grown stronger and deeper. I hope these hearings will help to show more clearly who this person, Clarence Thomas, is and what really makes me tick. My earliest memories, as alluded to earlier, are those of Pinpoint, Georgia, a life far removed in space and time from this room, this day, and this moment. As kids, we caught minnows in the creeks, fiddler crabs in the marshes, we played with pluffers, and skipped shells across the water. It was a world so vastly different from all this. In 1955, my brother and I went to live with my mother in Savannah. We lived in one room in a tenement. We shared a kitchen with other tenants, and we had a common bathroom in the backyard, which was unworkable and unusable. It was hard, but it was all we had and all there was. Our mother only earned $20 every 2 weeks as a maid. not enough to take care of us. So she arranged for us to live with our grandparents later in 1955. Imagine, if you will, 2 little boys with all their belongings in 2 grocery bags. Our grandparents were 2 great and wonderful people who loved us dearly. I wish they were sitting here today, sitting here so that they could see that all their efforts, their hard work, were not in vain. And so that they could see that hard work and strong values can make for a better life. I am grateful that my mother and my sister could be here. Unfortunately, my brother could not be. I attended segregated parochial schools and later attended a seminary near Savannah. The nuns gave us hope and belief in ourselves when society didn't. They reinforced the importance of religious beliefs in our personal lives. Sister Mary Virgilius, my 8th grade teacher, and the other nuns were unyielding in their expectations that we use all of our talents, no matter what the rest of the world said or did. After high school, I left Savannah and attended Immaculate Conception Seminary, then Holy Cross College. I attended Yale Law School. Yale had opened its doors, its heart, its conscience to recruit and admit minority students. I benefited from this effort. My career is as been delineated today. I was an assistant attorney general in the state of Missouri. I was an attorney in the corporate law department of Monsanto Company. I joined Senator Danforth's staff here in the Senate. I was an assistant secretary in the Department of Education, chairman of EEOC, and since 1990, a judge on the U.S. Court of Appeals for the District of Columbia Circuit. But for the efforts of so many others who have gone before me, I would not be here today. It would be unimaginable. Only by standing on their shoulders could I be here. At each turn in my life, each obstacle confronted, each fork in the road, someone came along to help. I remember, for example, in 1974, after I completed law school, I had no money, no place to live. Mrs. Margaret Bush Wilson, who would later become chairperson of the NAACP, allowed me to live at her house. She provided me not only with room and board, but advice, counsel, and guidance. As I left her house that summer, I asked her, "How much do I owe you?" Her response was, "Just along the way, help someone who's in your position." I have tried to live by my promise to her to do just that, to help others. So many others gave their lives, their blood, their talents. But for them, I would not be here. Justice Marshall, whose seat I've been nominated to fill, is one of those who had the courage and the intellect. He's one of the great architects of the legal battles to open doors that seemed so hopelessly and permanently sealed, and to knock down barriers that seemed so insurmountable to those of us in the pinpoint Georgias of the world. The Civil Rights Movement, Reverend Martin Luther King and the SCLC, Roy Wilkins and the NAACP, Whitney Young and the Urban League, Fannie Lou Hamer, Rosa Parks, and Dorothy Height. They changed society and made it reach out and affirmatively help. I have benefited greatly from their efforts, but for them, there would have been no road to travel. My grandparents always said there would be more opportunities for us. I can still hear my grandfather. Y'all gonna have more of a chance than me. And he was right. He felt that if others sacrificed and created opportunities for us, we had an obligation to work hard, to be decent citizens, to be fair and good people. And he was right. You see, Mr. Chairman, my grandparents grew up and lived their lives in an era of blatant segregation and overt discrimination. Their sense of fairness was molded in a crucible of unfairness. I watched as my grandfather was called boy. I watched as my grandmother suffered the indignity of being denied the use of a bathroom. But through it all, they remained fair, decent, good people. Fair in spite of the terrible contradictions in our country. They were hardworking, productive people who always gave back to others. They gave produce from the farm, fuel oil from the fuel oil truck. They bought groceries for those who were without. And they never lost sight of the promise of a better tomorrow. I follow in their footsteps, and I have always tried to give back. Over the years, I have grown and matured. I've learned to listen carefully to other points of views and to others, to think through problems, recognizing that there are no easy answers to difficult problems, to think deeply about those who will be affected by the decisions that I make and the decisions made by others. But I've always carried in my heart the world, the life, the people, the values of my youth, the values of my grandparents and my neighbors, the values of people who believed so very deeply in this country in spite of all the contradictions. It is my hope that when these hearings are completed, that this committee will conclude that I am an honest, decent, fair person. I believe that the obligations and responsibilities of a judge, in essence, involve just such basic values. A judge must be fair and impartial. A judge must not bring to his job, to the court, the baggage of preconceived notions, of ideology, and certainly not an agenda. And the judge must get the decision right. Because when all is said and done, the little guy, the average person, the people of Pinpoint, the real people of America will be affected not only by what we as judges do, but by the way we do our jobs. If confirmed by the Senate, I pledge that I will preserve and protect our Constitution and carry with me the values of my heritage: fairness, integrity, open-mindedness, honesty, and hard work. Thank you, Mr. Chairman.
Thank you very, very much for a moving statement, Judge. And let me begin at the very outset by pointing out to you, I, for one, do not in any way doubt your honesty, your decency, or your fairness. But if I could make an analogy, I am interested in what you think, how you think, I don't doubt for a moment the honesty, decency, or fairness of Senator Hatch. I don't doubt for a moment the honesty, decency, or fairness of Senator Metzenbaum. But I sure have a choice of which one I would put on the bench. Because they're both honest. I mean this sincerely now. It's an important point, at least if you understand what I have in mind. The fact you're honest, the fact you're decent, the fact you're fair, the fact you have honed sensibilities mean a lot to me. But what I want to do the next half hour and the next several days is to go beyond that. I will concede easily, because it's true, those points, no question. As we lawyers say, let's stipulate to the fact you're honest, decent, and fair. And let's get about the business of finding out why anyone who ever had the nuns can remember their 8th grade nun. Mine was Mother Agnes Constance. I don't know why I remember it so vividly. I suspect we both know why we remember so vividly.
Dare not forget.
And we both know they never forget. I made a speech not too many years ago, a commencement speech at St. Joseph's University. After the speech was over, I felt that finger that I'm sure you felt in the middle of your back. And I heard, Joey Biden, why did you say I instead of me in such and such a sentence? It's a true story. Turned around, was my 7th grade nun. So we both have at least that in common. And let's see what we can find out about whether or not we have in common, if anything, about the broader philosophic constructs upon which the Constitution can and must be informed. Judge, as Senator Danforth said, he hopes we have read your speeches. I assure you, I have read all of your speeches, and I have read them in their entirety. And as I indicated in my opening statement, what I want to talk about a little bit is one of the things you mention repeatedly in your speeches, so that I can be better informed about what you mean by it. Whether you're speaking the speech you delivered on the occasion of Martin Luther King's birthday, national holiday, and whether it should be one, to a conservative audience, making the point that he should be looked to with more reverence, or whether or not it was your speech at the Pacific Institute, or whether or not it's the Harvard Journal, whatever it is, you repeatedly invoke the phrase natural rights or natural law. And as I said at the outset, there's good natural law, if you will, and bad natural law in terms of informing the Constitution. And there's a whole new school of thought in America that would like very much to use natural law to lower the protections for individuals in the zone of personal privacy, and I will speak to those later, and who want to heighten the protection for businesses and corporations. Now, one of those people is a Professor Macedo, a fine first-class scholar at Harvard University. Another is Mr. Epstein, a professor at the University of Chicago. And in the speech you gave in 1987 to the Pacific Research Institute, you said, and I quote, "I find attractive the arguments of scholars such as Stephen Macedo, who defend an activist Supreme Court that would, not could, would strike down laws restricting property rights." My question is a very simple one, Judge. What exactly do you find attractive about the arguments of Professor Macedo and other scholars like him?
Senator, again, it's been quite some time since I've read Professor Macedo and others. That was, I believe, 87 or 88. My interest in the whole area was as a political philosophy. My interest was in reassessing and demonstrating a sense that we understood what our founding fathers were thinking when they used phrases such as all men are created equal and what that meant for our form of government. I found Macedo interesting and his arguments interesting as I remembered. Again, it's been quite some time, but I don't believe that in my writings I have indicated that we should have an activist Supreme Court or that we should have any form of activism on the Supreme Court. Again, I found his arguments interesting. And I was not talking, particularly with natural law, Mr. Chairman, in a context of adjudication.
Well, I'm not quite sure I understand your answer, Judge. You indicated that you find the arguments not interesting, attractive. And you explicitly say one of the things you find attractive, I'm quoting from you, I find attractive the arguments of scholars such as Stephen Macedo, who defend an activist Supreme Court that would strike down laws restricting property rights. Now, it would seem to me what you were talking about is you find attractive the fact that they're activists and they'd like to strike down existing laws that impact on restricting the use of property rights, because you know that's what they write about.
Yeah, well, let me clarify something. I think it's important, Mr. Chairman. As I indicated, I believe, or attempted to allude to in my confirmation to the Court of Appeals, I don't see a role for the use of natural law in constitutional adjudication. My interest in exploring natural law and natural rights was purely in the context of political theory. I was interested in that. There were debates that I had with individuals, and I pursued that on a part-time basis. I was an agency chairman.
Judge, in preparing for these hearings, some suggest that might be your answer.
Yeah.
So I went back through some of your writings and speeches to see if I misread them. And quite frankly, I find it hard to square your speeches, which I'll discuss with you in a minute, what you're telling me today. Just let me read some of your quotes. In a speech before the Federalist Society at the University of Virginia, in a variation of that speech that you published in the Harvard Journal of Law and Policy, you praised the first Justice Harlan's opinion in Plessy versus Ferguson, and you said, implicit reliance on political first principles was implicit rather than explicit, as is generally appropriate for the court's opinions. He gives us a foundation for interpreting not only cases involving race, but the entire Constitution and its scheme of protecting rights. You went on to say, Harlan's opinion provides one of our best examples of natural law and higher law jurisprudence. And then you say, the higher law background of the American government, whether explicitly applied to, appealed to or not, provides the only firm basis for a just and wise constitutional decision. And Judge, what I'd like to know is, I find it hard to understand how you can say that what you're now saying, that natural law was only, you're only talking about the philosophy in a general philosophic sense and not how it informed or impacted upon constitutional interpretation.
Well, let me attempt to clarify. That, in fact, though, was my approach. I was interested in the political theory standpoint. I was not interested in constitutional adjudication. I was not, at the time, adjudicating cases. But with respect to the background, I think that we can both agree that the founders of our country, or at least some of the drafters of our Constitution and our Declaration, believed in natural rights. And my point was simply that in understanding overall our constitutional government, that it was important that we understood how they believed or what they believed in natural law or natural rights. Now, my purpose was this, in looking at this entire area. The question for me was, from a political theory standpoint, you and I are sitting here in Washington, D.C. with Abraham Lincoln or with Frederick Douglass. And from a theory, how do we get out of slavery? There is no constitutional amendment. There's no provision in the Constitution. But by what theory? And repeatedly, Lincoln referred to the notion that all men are created equal. And that was my attraction to, or beginning of my attraction to this approach. But I did not, and would maintain that I did not feel that natural rights or natural law has a basis or has a use in constitutional adjudication.
Well, Judge, what was the? Let's go back to Macedo then. What was the political theory you found so attractive that Mr. Macedo was espousing?
The only thing that I could think of with respect to, and I'll tell you how I got to the issue of property rights and the issue of the approach or what I was concerned about. What I was concerned was this: if you ended slavery, and it's something that I don't know whether I alluded to it in that speech, but it's something that troubled me even in my youth. If you ended slavery and you had black codes, for example, or you had laws that did not allow my grandfather to enjoy the fruits of his labor, prevented him from working, and you did have that. You had people who had to work for $3 a day. I told you what my mother's income was. By what theory do you protect that? I don't think that I have explicitly endorsed Macedo. I found his arguments interesting, and again, that's been...
About any of those things, Judge?
I understand that. I read more than explicit areas. I read about natural law, even though my grandfather didn't talk about natural law.
But, I mean, isn't it kind of... Well, without... I guess, well, I'll come back to Macedo, but let me... you also said in that speech out at the Pacific Research Institute, you said, quote, "I am far from being a scholar on Thomas Jefferson, but two of his statements suffice as a basis for restoring our original founding belief and reliance on natural law. And natural law, when applied to America, means not medieval stultification, but the liberation of commerce." You speak many times, I won't bore you with them, but I have pages and pages of quotes where you talk about natural law not in the context of your grandfather, not in the context of race, not in the context of equality, but you talk about it in the context of commerce, just like it is talked in the context, by Macedo and by Epstein and others in their various books, a new fervent area of scholarship that basically says, hey, look, the modern day court, has not taken enough time to protect people's property, the property rights of corporations, the property rights of individuals, the property rights of businesses. And so what we have to do is we have to elevate the way we've treated protecting property. We have to elevate that to make it harder for governments to interfere with the ability of, in the case of Epstein, the ability to have zoning laws, the ability to have pollution laws, the ability to have laws that protect the public welfare. And then you say, in another place in one of your speeches, you say, well, look, I think that property rights should be given, let me find the exact quote, should be given the exact same protection as, you say, economic rights are as protected as much as any other rights, in a speech to the American Bar Association. Now, Judge, you understand my confusion. Economic rights now are not protected as much as any other rights. They are not protected that way now. They are given, if they pass a rational basis test in effect, it's all right to restrict property. But when you start to restrict things that have to do with privacy and thought and process, then you have to have a much stricter test. And so you quote Macedo, you talk about the liberation of commerce and natural law, whatever you want to call it, natural law or not, and then you say economic rights. And by the way, you made that speech to the ABA the day after you made the speech where you praised Macedo. Can you tell me, can you enlighten me on how this was just some sort of philosophic musing?
Well, that's exactly what it was. I was interested in exactly what I've said I was interested in. And I think I have indicated in my confirmation to the Court of Appeals that I did not see a role for the application of natural rights to constitutional adjudication. And I stand by that.
Judge, you argue Harlan did just that, and it was a good thing for him to have done. He applied this theory of natural rights, as you say, in his dissent in Plessy.
I thought that...
And he should have, you say.
Well, the argument was I felt that slavery was wrong, that segregation was wrong.
Right.
And again, I argue, and I have stood by that, that these positions that I've taken from the standpoint of philosophical or from the standpoint of political theory.
Well, Judge, let me find...
Well, if I could have an opportunity,
please.
Mr. Chairman.
Please.
My interest in this area started with the notion, with a simple question. How do you end slavery? By what theory do you end slavery? After you end slavery, by what theory do you protect the right of someone who was a former slave, or someone like my grandfather, for example, to enjoy the fruits of his or her labor? At no point did I or do I believe that the approach of natural law or that natural rights has a role in constitutional adjudication. I attempted to make that plain or to allude to that in my confirmation to the Court of Appeals, and I think that that's the position that I take here.
Okay, Judge. Well, look, let's not call it natural law, natural rights, whatever. What do you mean when you say economic rights are protected as much as any other rights in the Constitution? What do you mean by that?
Well, the simple point was that notions like, for me, at this point, and again, I have not gone back and I don't know the text of all those speeches, but there are takings clause. There is a taking clause in the Constitution, and there's also a reference to property in our Constitution. That does not necessarily mean that in constitutional adjudication that the protection would be at the same level that we protect other rights. Nor did I suggest that in constitutional adjudication that would happen. But it certainly does deserve some protection. And certainly the right of my grandfather to work deserves protection.
The right of my grandfather Finnegan to work, too, deserved protection. Yes. And your grandfather to work. But the issue here is whether, and look, let me explain to you why I'm concerned about this. You know why, and let's make sure other people know why. Mm-hmm. There's a whole new school of thought that up until about 5 years ago only spoke to one another, that is now receiving wider credence and credibility, to the point that former Solicitor General Charles Fried, in his book Order and Law, not a liberal Democrat, Reagan's Solicitor General, said in his book about this group of scholars to whom Macedo and others like you refer, maybe you didn't mean the same thing, but this group of scholars, meaning Macedo and Epstein and others who I'll mention in a moment, he says, devotees, it says fledgling Federalist societies and often devotees of the extreme libertarian views of Chicago law professor Richard Epstein had a specific, aggressive, and it seemed to me quite radical project in mind, meaning for the administration. And it seemed to me a quite radical project in mind to use the takings clause, and I don't have much time so I won't go into it, but you and I both know the takings clause is that portion of the Fifth Amendment that has nothing to do with self-incrimination. It says the government's going to take your property, they have to pay for it. Except historically we've said if it's regulating your property, it is not taking it. If it's regulating under the police power to prevent pollution or whatever else, then it's not taking it. It doesn't have to pay for it. And what these guys want to do is they want to use that takings clause like the 14th Amendment was used during the Lochner era. This is Fried speaking. It says, had a specific, aggressive, and it seemed to me quite radical project in mind to use the takings clause of the Fifth Amendment to serve as a brake upon federal and state regulation of business and property. The grand plan was to make government pay compensation for taking property every time its regulation impinged. Now that's what this is all about, Judge. And again, I'm not saying that that's your view, but it seems to me when you say, which nobody else who writes in this area, I don't know anybody, and I've read a lot about this area, I don't know anybody else who uses the phrases natural law, property, the takings clause, who doesn't stand for the proposition that Macedo and Epstein stand for, which is that we got this little out of whack. We got to elevate the standard of review we use when we look at property, just to the same standard, to use your phrase, the same rights as personal rights that most Americans think to be personal, whether they can assemble, whether or not they can go out and speak, whether or not they can worship, whether or not they can have privacy in their own bedroom. And so these guys want to change that balance. But that's why I'm asking you this. I'll come back to it in a minute in my second round, but let me shift, if I may. Oh, yeah, please, yeah.
First of all, I would like to just simply say, and I think it is appropriate, that I do not consider myself a member of that school of thought. And secondly, I think that the post-Lochner era cases were correctly decided. My interest in natural rights were purely from a political theory standpoint and as a part-time political theorist. I was not a law professor, nor was I adjudicating cases. And as I indicated and have indicated, I do not think that the natural rights or natural law has an appropriate use in constitutional adjudication.
Well, Judge, I'd ask for the record, and I'll make these available to you, that all the references you make that I have found, and there's pages of them, where you explicitly connect natural law with either specific cases or talk about informing specific aspects of constitutional interpretation, be entered in the record. And in my second round, I'll be able to talk with you about them. You'll have had a chance to read them. But let me move, if I may, for a second. As I said earlier, I mentioned that concomitant with those who want to sort of raise up the economic protections of business and corporation to make it harder for government to regulate them without paying them, which is a multi-billion-dollar change in the law, where, not your view, where Mr. Epstein's views to take place, be a multi-billion-dollar expense for the taxpayers if they wanted to continue to regulate the way we now regulate and consider reasonable. As I mentioned earlier, there's a second zone of individual rights, a zone which includes such rights as free speech, religion, and privacy in the family. And these rights are also protected by the Constitution as informed by natural law principles. Now, you say that's not what you mean, informed by natural law principles, but some of the specific protections are very specific. For example, the Fourth Amendment guarantees personal privacy in a particular context, illegal search and seizures, and other protections are more general, like the 14th Amendment that says no state, nor shall any state deprive any person of life, liberty, or property without due process of law. Now, Judge, in your view, does the Liberty Clause of the 14th Amendment protect the right of women to decide for themselves in certain instances whether or not to terminate pregnancy?
Senator, first of all, let me look at that in the context other than with natural law principles.
Let's forget about natural law for a minute, if you'd like to.
My view is that there is a right to privacy in the 14th Amendment.
Well, Judge, does that right to privacy in the Liberty Clause of the 14th Amendment protect the right of a woman to decide for herself in certain instances whether or not to terminate a pregnancy?
Senator, I think that the Supreme Court has made clear that the issue of marital privacy is protected, that the state cannot infringe on that without a compelling interest. And the Supreme Court, of course, in the case of Roe v. Wade, has found an interest in the woman's right to, as a fundamental interest, a woman's right to terminate a pregnancy. And I do not think that at this time that I could maintain my impartiality as a member of the judiciary and comment on that specific case.
Well, let's try it another way, Judge. I don't want to ask you to comment on specifically on Roe then. What I'm trying to get at is there's sort of two schools, not sort of, there are two schools of thought out there. There's fellas, there's a gentleman like Professor Michael Moore of the University of Pennsylvania and Mr. Louis Lehrman of the Heritage Foundation, who both think natural law philosophy informs their view. And they conclude, one who strongly supports a woman's right and the other one who strongly opposes a woman's right to terminate a pregnancy. And then there are those who say that no, this should be left strictly to the legislative bodies, not for the courts to interpret. And they fall into the school of thought that represented by John Hart Ely and former Judge Robert Bork, for example, who say the court has nothing to do with that. Now, let me ask you this. Where does the decision lie? Does it lie with the court? For example, you quote with admiration the Mr. Lehrman's article. Mr. Lehrman's article was on natural law and I forget the exact title here. Let me find it. Natural law and the right to life. And you say when you are speaking at a gathering that you think that is a superb application of natural law. You say, it quotes, it's a splendid example of applying natural law. Now, what do you mean by that?
Well, let me go back to, I guess, my first comment to you when we were discussing natural law, and I think that is important, and then come back to the question of the due process analysis. The speech that I was giving there was before the Heritage Foundation. Again, as I indicated earlier, my interest was civil rights and slavery. What I was attempting to do in the beginning of that speech was to make clear to a conservative audience that blacks who were Republicans and the issues that affected blacks were being addressed and being dealt with by conservative in what I considered a less than acceptable manner. The second point that—
in what sense? In that they were not—
that they were not
invoking natural law?
No, no. The second point that I wanted to make to them was that they had, based on what I thought was an appropriate approach, they had an obligation, just as conservatives, to be more open and more aggressive on civil rights enforcement. What I thought would be the best way to approach that would be using the underlying concept of our Constitution, that we were all created equal. One, I felt that conservatives would be skeptical about the notion of natural law. I was using that as the underlying approach. I felt that they would be conservative and that they would not or be skeptical about that concept. I was speaking in the Lou Lehrman Auditorium of the Heritage Foundation. I thought that if I demonstrated that one of their own accepted at least the concept of natural rights, that they would be more apt to accept that concept as an underlying principle for being more aggressive on civil rights. My whole interest was civil rights enforcement.
Judge, you said in that speech, the need to re-examine natural law is as current as last month's issue of Time on Ethics. Yet it is more venerable than St. Thomas Aquinas. It both transcends and underlies time and place, race and custom. And until recently, it has been an integral part of the American political tradition. Dr. King was the last prominent American political figure to appeal to it. But Heritage trustees Louis Lehrman's recent essay in the American Sector on the Declaration of Independence and the meaning of the right to life is a splendid example of applying it. Briefly put, this thesis of natural law is that human nature provides the key to how men ought to live their lives. And then Mr. Lehrman's article goes on, not you, Mr. Lehrman's article goes on and says, because it is a natural right of a fetus, there is no ability of the legislative body to impact in any way on whether or not there can or cannot be an abortion at any time for any reason. And the court must uphold, applying natural law, the principle that abortion is wrong under all circumstances, whether it's the life of the mother or no matter what, all circumstances. Now,
it was not my intention, Mr. Chairman, as I've tried to indicate to you, to adopt. I think I've been explicit when I wanted to adopt someone or say something, adopt a position or say something. I think I have done that. My interest in the speech, I think, is fairly clear, or is very clear. My interest was in the aggressive enforcement of civil rights. Remember the context. I'm in the Reagan administration. I've been engaged in significant battles throughout my tenure. It is toward the end of the Reagan administration, and I feel that conservatives have taken an approach on civil rights where they have become comfortable with notions that it is okay to simply be against quotas or to be against busing or to be against voting rights and consider that a civil rights agenda. What I was looking for were unifying themes in a political standpoint, not a constitutional adjudication standpoint. And I used themes that I thought that one of their champions had in a way adopted. Not adopting his analysis or adopting his approach, but adopting a theme that he used to serve the purposes that I thought were very important.
Well, Judge, let me conclude this round by saying that, in picking up that context, that you were part of the Reagan administration. In '86, as a member of that administration, you were part of what's been referred to here, the administration's working group on the family. And this group put out what I think can only be characterized as a controversial report. You signed that report, which recommends more state regulation of the family than is now allowed under the law. That report concludes that the Supreme Court's privacy decisions for the last 20 years are fatally flawed and should be corrected. Judge, did you read this report before it was released?
Well, let me explain to you how working groups work in the domestic policy context, or the way that they worked in the administration. Normally what would happen is that there would be a number of informal meetings.
Do you have that document?
At those meetings, you would express your, there would be some discussion around the table. My interest was in low-income families. I transmitted to, after several meetings, transmitted to the head of that working group my views on the low-income family and the need to address the problems of low-income families in the report. The report, as it normally works in these working groups in domestic policy, the report is not finalized, nor is it a team effort in drafting. You are submitted your document. That document is then, as far as I know, it may be sent around or may not be sent around. But there's no signature required on those. And it's normal.
Read the report, Judge.
The section that I read was on the family. I was only interested in whether they included my comments on the low-income family.
But at any time, even after it was published?
No, I did not.
You haven't, to this moment, read that report?
To this day, I have not read that report. I read the sections on low-income families.
There was an awful lot of discussion in the press and controversy about it.
There was controversy about it. I was interested in low-income families. If you've worked with the domestic policy group or the working groups at the White House, what one quickly learns is that you send your input, that input is reduced to what they want it reduced to.
Gotcha.
And then the report is circulated and final.
Well, let me conclude. This is the last thing I will ask you. This report, which is only 67 pages long, of which your report is part of, and I acknowledge you're telling us that you did not read the report before or after, and your part was only a small part of this. But in this report, take my word for it, it says that one of these fatally flawed decisions and they explicitly pick out one, is the Moore versus the City of East Cleveland, where the City of East Cleveland said a grandmother raising 2 grandchildren who are cousins and not brothers is violating the zoning law, and therefore has to do one of 2 things: move out of the neighborhood or tell one of her grandchildren to leave. As you know, that case, I believe, that was appealed to the Supreme Court, that grandmother. And the court said, hey, no, she has an absolute right of privacy to be able to have 2 of those grandchildren, even though they're cousins, to live with her, and no zoning law can tell her otherwise. Now, this report says that explicitly, it says that the City of East Cleveland and other cities should be able to pass such laws if they want, and they should be upheld. And if we can't get them upheld, then we should change the court. That's what this report says. Now, and they say that the cities and states should be able to establish norms of a traditional family. If you will give me the benefit of the doubt that I'm telling you the truth and accurately characterizing the report on that point, do you agree with what I suggested to you is the conclusion of that report in the section you have not read?
I have heard recently that that was the conclusion, but I'd like to make a point there. I think that, and I think the Supreme Court's rulings in the privacy area support that the notion of family is one of the most personal and most private relationships that we have in our country. If I had, of course, known that that section was in the report before it became final, of course I would have expressed my concerns. That
kind of outrageous, isn't it? I mean, isn't it an outrageous suggestion?
That would have had direct implications on my own family, that I could easily have been zoned out of my neighborhood should approaches like that take place. But my point to you, and I think it's very, very important, Senator, is this: that when you're involved or were involved in a working group in the White House, we were more in the nature of resource people. This was not a committee report. This was not a conference report, which was circulated normally for comment. It was something generally that you provided your input, and I provided a significant memo, I believe, on low-income family and families that I felt were at risk in this society, and how we should approach resolving those families. I do not remember there being any discussion of the final draft.
Well, I have much more to ask you, Judge. We're going to go back, when I get a chance again, to the Macedo quote and the ABA speech and the Lehrman speech and this report. But quite frankly, at this point, you leave me with more questions than answers. But let me yield to my distinguished colleague, Senator Thurman.
Mr. Chairman, before proceeding forward, I don't wish to interrupt my colleague, Senator Thurman. Would you be good enough to ask the judge to read that report in order that we might inquire further of him tomorrow in our question period?
Well, if you plan on inquiring of him, I will make sure he has a copy available, and he can decide whether he wishes to read it or not. But I will see to it that he has a copy, and he can make the judgment whether he wishes to read it. Senator Thurman.
Thank you, Mr. Chairman. Now, Judge, I think we can move right along. We have about 30 minutes in. I've got about 14 questions. I think we can finish them if you just make the answers fairly brief. Judge Thomas, the Constitution of the United States is now over 200 years old. Many Americans have expressed their views about the endurance of this great document. With the events in the Soviet Union, this document takes on an even greater significance as the foundation of our domestic form of government. Would you please share with the committee your opinion as to the success of our Constitution and its distinction as the oldest existing Constitution in the world today?
Senator, it's, I think should be clear to all.
Just speak in the machine and speak out so we can all hear you.
Senator, I think it should be clear to all of us that our Constitution, as it has endured, is one of the greatest documents, not only in our lifetimes, but certainly in the history of the world. It protects our freedoms as well as provides us for a structure of government that is certainly the freest government in the world. And it has certainly been a model for other countries.
Second question. Judge Thomas Marbury versus Madison is a famous Supreme Court decision. It provides the basis of the Supreme Court's authority to interpret the Constitution and issue decisions which are binding on both executive and legislative branches. Would you briefly discuss your views on this authority?
Senator, I think it's important to recognize, and we all do recognize, that Marbury versus Madison is the underpinning of our current judicial system, that the courts do decide and do the cases in the constitutional area, and it's certainly an approach that we've grown accustomed to and around which our institutions, our legal institutions, have grown up.
Judge Thomas, the 10th Amendment to the Constitution provides that all powers are reserved to the states or the people, if not specifically delegated to the federal government. What is your general view about the proper relationship between the federal and state governments, and do you believe that there has been a substantial increase in federal authority over the last few decades?
Senator, I think that it's clear that our country has grown and expanded in very important ways. That the commerce, through the Commerce Clause, for example, there's been growth in the national scope of our government. Through the 14th Amendment, there have been application of our Bill of Rights or portions to the state governments. Through the growth in communications and travel, of course, we're more nationalized than we were in the past. I think what the court has attempted to do is to preserve in a way as best it possibly could the autonomy of the state governments, but at the same time recognize the growth and expansion and the natural growth and expansion of our national government.
Judge Thomas, some have discussed your tenure as chairman of the Equal Employment Opportunity Commission since your nomination to the Supreme Court. Although this committee has thoroughly reviewed the issues raised about the EEOC when you were nominated for the D.C. Circuit Court, would you tell the committee what earlier problems you encountered as the EEOC, at the EEOC, and the steps you took to resolve them? And if you care to discuss any major accomplishments, I'd be glad to have you do so.
Senator, that's EEOC, of course, was a significant portion of my career in government. It was the most important part. When I arrived at EEOC in 1982, of course, we had some very, very difficult problems. We had problems with respect to the infrastructure of the agency. I felt that we should investigate more cases and that we should litigate more cases. We were immediately faced with problems of just managing our own money in the agency. Over time, we were able to solve those problems. Over time, we were able to correct the infrastructure and to develop it, and ultimately to improve our enforcement. We litigated more cases than ever in the history of the agency. We've been able to investigate cases, and we were able to do more with less in the agency with fewer resources. So I am very proud of my tenure at EEOC. I think we made great accomplishments. I think we made great strides. I think there was a lot to do after I left, and I felt that the agency was headed in a very positive direction.
Judge Thomas, the Supreme Court has ruled that the death penalty is constitutional. There are hundreds of inmates under death sentences across the country. Many have been on death row for several years as a result of the endless appeals process. Recently, the Senate passed legislation which would reduce the number of unnecessary appeals by giving greater deference to state decisions. Additionally, the Supreme Court has ruled in certain cases that there should be limits to the endless filing of habeas petitions, especially in death penalty cases. Would you give the committee your views on the validity of placing some reasonable limitations on the number of post-trial appeals in death penalty cases?
Senator, generally, I think that there would be a concern among all of us. The death penalty is the harshest penalty that can be imposed, and it's certainly one that is unchangeable. and we should be most concerned about providing all the rights and all the due process that can be provided and should be provided to individuals who may face that kind of a consequence. I would be concerned, of course, that we would move too fast, that if we eliminate some of the protections, that perhaps we may deprive that individual of his life without due process. So I would be in favor of reasonable restrictions on procedures, but not to the point that individuals, or I believe that there should be reasonable restrictions at some point, but not to the point that an individual is deprived of his constitutional protections.
Judge Thomas, I believe that tough sentences should be imposed in criminal cases, especially when the crime committed is one of violence. Over the years, I have favored tough criminal sanctions. Too often, unfortunately, victims of crime have not played a prominent enough role in the criminal justice system. However, recently, the number of victims who participate in the prosecution of criminal cases has increased. In fact, the court recently ruled in the case of Payne versus Tennessee that the use of victim impact statements in death penalty cases does not violate the Constitution. In your opinion, should victims play a greater role in the criminal justice system? And if so, to what extent should a victim be allowed to participate, especially after a finding of guilt against an accused?
Of course, Senator, that's a matter that the court has recently, as you've noted, recently considered. My concern would be in a case like that we don't, in a way, jeopardize the rights of the victim. Of course, we'd like to make sure that the victims are involved in the process, but we should be very careful, in my view, of that we don't somehow undermine the validity of the process, that an individual who is a criminal defendant is in some way harmed by that, other than just simply getting it right and making sure that the total impact of the conduct is known. I think that there are concerns on both sides. From the standpoint of the victims, that's important, but there are also the constitutional right of the criminal defendant.
Judge, if I prepare any question you consider inappropriate, just speak out and tell me. Judge, Congress established the United States Sentencing Commission in 1984. Its function is to promulgate sentencing guidelines for federal judges to ensure uniform and predictable prison sentences. The Supreme Court ruled in the case of U.S. versus Smith Strata that the sentencing guidelines are constitutional. Judge Thomas, from your experience, do you believe that uniformity in sentencing is more fair to those individuals who commit similar crimes, and in the long run, that sentencing guidelines will create greater confidence in the criminal justice system?
Senator, I think that the problem, the concern that many individuals had in the sentencing of criminal defendants was the apparent unfairness in the disparity of sentences. The approach and the effort, the purpose of the uniform guideline, one of the purposes was to simply provide some sense or to eliminate that disparity and that sense of unfairness. To the extent that it has done that in eliminating that disparity, I think it has brought a sense of fairness to the process. The concern, of course, of anyone who is involved in the criminal justice system is that we do not sacrifice justice or fairness for uniformity or for rigidity. But I think that most judges would agree that the guidelines have brought or has eliminated the disparity in sentencing.
Judge Thomas, you are currently serving as a member of the United States Court of Appeals for the District of Columbia Circuit. You have participated in some 140 decisions. How beneficial, in your opinion, will your prior judicial experience be to you if confirmed to serve on the Supreme Court?
Senator, I think that in my own career, I've had the opportunity to work in a variety of positions. I've had an opportunity to work in the federal government, to be engaged in appellate work there, to represent agencies, as well as in the legislative and executive branches of the national government. What has been important to me in those processes is that I've had the opportunity to grow, to learn, to expand, to mature, to make hard decisions, and to, I think, become a better person and to become certainly advanced as someone who's capable of deciding tough cases or making tough decisions. When I moved to the judiciary, I felt that I had been matured, or I had matured rapidly. But when one goes to the judiciary, one puts on those robes and realizes the immense responsibility of being a judge. That at the end of a decision, something is going to happen. Perhaps a person may stay in a prison longer, or a person may leave prison. There may be some economic effects. There may be a change in a company. Somebody wins or someone loses. So one becomes more serious, and one again matures greatly. I think it is also important because a judge has to become accustomed to not having formed views on issues that may come before him or her. You become impartial or neutral. You begin to look at problems in a different way, and you recognize your fallibility. I think that my tenure on the Court of Appeals has been a tremendous benefit to me, and it certainly provided me with an occasion to mature more rapidly and to a larger extent than even my process of maturation in my previous jobs.
Judge Thomas, the doctrine of stare decisis is a concept well recognized in our legal system, and a concept that virtually all judges have in mind when making decisions, especially difficult cases. I am sure that the issue of prior authority has been a factor which you have considered while on the bench. Would you please briefly state your general view of stare decisis, and under what circumstances you would consider it appropriate to overrule prior procedure?
I think, of course, overruling a case is a very, or reconsidering a case, Senator, is a very serious matter. Certainly the case would have to be, you would have to be of the view that the case is incorrectly decided. But I think even that is not adequate. There are some cases that you may not agree with that should not be overruled. Stare decisis provides continuity to our system. It provides predictability, and in our process of case-by-case decision-making, I think it is a very important and critical concept. And I think that a judge has the burden. A judge who wants to reconsider a case, and certainly one who wants to overrule a case, has the burden of demonstrating that not only is the case indirect, but that it would be appropriate in view of stare decisis to make that additional step of overruling that case.
Judge Thomas, under our Constitution, we have three very distinct branches of government. The role of the judiciary is to interpret the law. However, there have been times when judges have gone beyond their responsibility of interpreting the law and instead have exercised their individual will as judicial activists. Would you please briefly describe your views on the topic of judicial activism?
I think, Senator, that the role of a judge is a limited one. It is to interpret the intent of Congress, the legislation of Congress, to apply that in specific cases, and to interpret the Constitution where called upon, but at no point to impose his or her will or his or her opinion in that process, but rather to go to the traditional tools of constitutional interpretation or adjudication, as well as to statutory construction, but not, again, to impose his or her own point of view or his or her predilections or preconceptions.
Judge Thomas, the exclusionary rule is well known in criminal law. At times it is applied when there was no misconduct on the part of law enforcement. For this reason, the Supreme Court recognized a good faith exception to the exclusionary rule in the case of U.S. versus Leon, applying it to only searches made pursuant to a warrant. Judge Thomas, would you discuss the effect of the exclusionary rule in preventing police misconduct and whether or not there is a valid basis for a good faith exception, especially when there's a search warrant?
I think in the case of U.S. v. Leon, of course, the court did find a good faith exception, but the approach that the court took and the concern was this, that the warrant and the requirement is to make sure that the law enforcement officials are deterred from pursuing in an unlawful way or obtaining evidence in an unlawful way, that it will not be used in the process. In U.S. v. Leon, as I remember it, the magistrate had issued a warrant and the police officers or the law enforcement officials had relied on that warrant in good faith. The court is simply saying that it would serve no purpose of deterrence by precluding the use of a warrant that was issued by a magistrate, perhaps by mistake, but relied on then in good faith by the law enforcement officials. Of course, there are exceptions to that, but I think that the court and the law enforcement community have come to accept the use of the exclusionary rule up to a point, and the court is looking for ways to make sure that the purposes of the exclusionary rule are advanced as opposed to simply being used in a way that is rote.
Judge Thomas, concerns have been raised recently about the high cost and sometimes lengthy delays to resolve civil cases in the federal courts. Last year, Congress passed legislation that I introduced along with Senator Biden that requires each federal district to prepare a proposal to reduce delay and costs in the federal civil litigation process. In your view, is there a need to expedite civil cases and reduce costs to ensure that individuals have confidence in the courts to resolve disputes? And what would you recommend to improve handling of civil cases in the federal courts?
Senator, I think that the concern that any of us would have when a court has a crowded document is that there would be individuals who most need the access to our judicial system who would be squeezed out of that system. And we would also be concerned that if the cost of civil litigation were to increase, once again the individuals who most need access to our judicial system would be eliminated from that system. I think that there have been some proposals by the Vice President. There have been approaches that involve dispute resolution in order to speed up the process. There have even been private individuals who have established ways to adjudicate cases. My concern with the latter approach, of course, would be that we would have separate judicial systems. For those who can afford it, the private system, and for those who can't, they would have to wait in line for a crowded governmental system. But I think that there are some proposals. Of course, there's discussion, and I think that at all times the judicial system should be open to all of our citizens. It's one common thing that aspect of our government that we all have, the same judiciary.
Judge Thomas, in an opinion written last year by Justice Scalia concerning the First Amendment's freedom of religion, the Supreme Court ruled in Employment Division versus Smith that a law which is otherwise valid does not violate the First Amendment if it incidentally affects religious practices. Would you please briefly discuss the impact this decision has on the compelling state interest test established in Sherwood versus Verner in 1963?
Of course, the Justice Scalia's decision was in essence that since the general criminal statutes outlawed the use of peyote, I think in that case, that one could not claim that it was a violation of their First Amendment right to exercise their religious beliefs, that this preclusion by statute had occurred, or that you could not use it in a religious exercise of any sort or religious celebration. What Justice Scalia did was actually use a different test than had been used in the past. He avoided using the Sherbet test. Justice O'Connor used the compelling interest test. She used the Sherbet test and reached the same result, if I remember the case right. I think it is an important departure from prior approaches, and it's one that anyone who approaches these cases should be concerned about, or at least be watchful for.
Judge Thomas, the issue of capital punishment is a controversial topic with strongly held views on both sides. However, the Supreme Court has ruled that the death penalty is a constitutional form of punishment, provided steps are taken to ensure that it is not imposed with unfettered discretion. Certainly, there are judges who are personally opposed to the death penalty. Since the Supreme Court has ruled that the death penalty is constitutional, what role, if any, should the personal opinion of a judge play in decisions he or she may render in cases such as the death penalty?
Senator, I think as I've indicated, I don't think that a judge's personal opinions should play a role in deciding on cases. And certainly if a judge has strongly held views to a point that he or she cannot be impartial or objective, then I think that judge should consider recusal. I think that, of course, some judges believe that the death penalty per se may be violative of constitutional rights, and that's one form of analysis or approach. But I think that if your personal views are so strong in any area, you should consider recusal.
Judge Thomas, there have been complaints by federal and state judges regarding the inferior quality of advocacy before the courts. During your service on the bench, have you found that legal representation in the courts was adequate? And what, in your opinion, should be done to ensure that individuals get quality representation in the courts?
Senator, during my own law school years, I thought it was important that I be involved as a law student in providing some representation for individuals who could not afford lawyers. I think we would all agree that in our judicial process and in this complex world that it's difficult to represent oneself. And while I was in the Attorney General's office, I attempted to, as well as at Monsanto Company, I attempted to provide services to individuals who needed assistance. I think that the level of representation or the level of advocacy by the lawyers who have appeared before the court on which I currently sit has been very, very high. The lawyers' involvement in the process help us to sharpen the arguments, to understand the arguments, and certainly to sharpen our inquiry and our analysis of very, very difficult legal issues. I think it's important not only from the standpoint, and I think it's critical that individuals be represented, but I think it's not only important from that standpoint, but also from the standpoint of judges being able to get the cases right.
Judge Thomas, prison overcrowding is a major problem facing federal and state institutions today. Several state systems are currently under federal prisoner cap orders which limit committing additional inmates to certain prisons. At a time when violent crime and drug offenses are such a problem, what other alternatives are available to ensure that prison space is available for those sentenced to serve time?
That's a difficult question, Senator. I don't think that those of us in the judiciary have the ability to know exactly how to solve all of the prison overcrowding issues. That of course is a problem that's facing virtually all areas. There have been efforts to move individuals to areas other than where they're convicted, to areas where they have additional space, and there have been efforts to use other facilities, perhaps military bases, etc. But I think that it's a problem that's worthy of reconsideration, and it's one that with the current prison population has to currently be re-examined not only by this body or similar bodies, but also law enforcement officials as well as members of the judiciary.
Judge Thomas, as you are aware, product liability cases often involve very complex issues with large sums of money at stake. Many argue that Congress should pass reform legislation to modify the burden of proof in certain type cases and to limit the amount of damages that jurors would be allowed to award. Based on your experience as a judge, what is your opinion of the ability of a judge in such complicated trials to comprehend these intricate issues and award damages reasonably related to the injuries suffered by the plaintiff? And if juries grant unwarranted awards, can appellate courts correct them?
Senator, those cases are very difficult cases. I think that when juries and when judges attempt to adjudicate those cases, they have to sort out a complex set of issues as well as determine in difficult circumstances what the appropriate relief would be. At the appellate level, our job is not simply to go back and impose our views on the trier of fact in those cases, but rather to assure that the appropriate standards of law were employed.
Judge Thomas, many people have supported the enactment of alternative dispute resolution measures, such as arbitration, in products liability lawsuits. Do you believe that these alternative dispute resolution measures will work in a fair manner and be helpful in resolving complicated issues that are usually considered by a jury, as well as helping to expedite the handling of such cases?
We used, Senator, the alternative dispute resolution process. We began during my tenure at EEOC to begin to take a look at those sorts of approaches to resolving very difficult problems. And I believe that they should be explored. In our own court, we have explored the use of that process in resolving some of the appellate cases. Again, I think it's necessary to make sure that the cases that are allowed to go through that process are those that are susceptible to resolution in that manner. I would be concerned that any individual is deprived of his or her day in court by using mechanisms that are not directly in the judicial process.
Judge Thomas, the Sentencing Commission is considering whether the current federal criminal sentences are adequate. In fact, the Commission has promulgated new guidelines for white-collar and corporate offenses. Congress has also seen fit to increase the term of imprisonment for various white-collar crimes, including those involving financial institutions. From your experience, have penalties for white-collar and corporate defenders been sufficient? And do you anticipate tougher penalties for white-collar criminals in the future as a result of the recent savings of loan offenses and securities-related crimes?
Senator, I certainly have not sat as a trial judge imposing those sentences. I think that the sentences under our guidelines in the areas in which I've been involved certainly seem to be adequate. I would be concerned that there would be significant differences between serious crimes in one area and serious crimes in another area. And I think that this body, as well as individuals who've studied this area, have attempted to reduce the disparity in those sentences, and I think that's an important project and endeavor.
Judge Thomas, the caseload of the Supreme Court has grown rapidly over the past several decades. Part of this increase is a result of more cases being filed in the lower courts. Cases today are more complex as our laws have become far more numerous and intricately fashioned. Would you please give the committee your thoughts on the current caseload of the Supreme Court and comment briefly on any innovative methods which could be utilized at the federal level for handling this increased caseload?
I certainly couldn't, Senator, as much as I probably would like to advise the Supreme Court on its workload. I think that the judges on my court, and I would assume that justices on the Supreme Court, are working at a level that is very, very significant. I know that our own investment of time on our court usually involves 6 or 7 days a week. And of course, we do not have the option of screening the cases as the Supreme Court does. I think that the Supreme Court has the awesome task of making some of the most difficult decisions in our nations, and certainly the most difficult decisions in our judicial system. And it's important that they control their workload, I think, in a way that they can make these decisions in an appropriate manner.
Judge, the light is red. My time is up. Thank you very much.
Judge, you've been sitting there a long time. Why don't we take a, I'm going to try to get finished by 5:30, so why don't we take, why don't we come back at 20 after, okay? We'll recess till 20 after.
All right. I think C-SPAN probably ended this for me, so I'm not going to have much time, like a real 20-minute recess to talk about this. But, you know, natural law has come up. That's the senators want to know what he was going to, make his decisions based on. Is it going to be natural law or the Constitution? They're looking for the answer to the Constitution. It's funny because later in life, Thomas has said, he wasn't really expecting all this to come up about natural law. They're really harping on it. And some of the senators really harp on this talking about it. It's fun to watch. And let's see, we've really just gotten Biden and Strom Thurmond. Oh, is that better? Let me see if I can hear myself. What's going on with the mic? I need to reset my computer. if I touch anything, it's jumpy. Is it any better that I turned off the audio from the hearing? Turn up the mic. It's cranked. There's things on the back I don't know what they do, but I know once I touched them and it picked up all the devices. It's better. Okay. Yes. It's what's going on is the hearing, the what do you call, the background noise is so dang loud. It's I guess microphone technology has gotten much better. At least whatever Congress is using, throughout the years. So let's see. Natural law has come up. He asked, there was questions about the exclusion rule, exclusionary rule, which is interesting. Basically, let's say fruit of the poisonous tree, police come across evidence that they may have not been able to attain. Let's say they didn't have a warrant for it, but the evidence was obtained, and later that gets cured through some good faith finding. Thomas talked about that a little bit in his views on that. And he talks about how the good faith finding could cure that evidence. And that's the most substantive thing I think we've gotten so far. So other than that, let's see what we want to. What have we been talking about in the chat? We've been talking about Trump. I guess they're not trolling. It's a real debate that we're having here in the chat, which is there's a few people, Doug and Right is Right, have been talking about Donald Trump's Truth Social. And I think he's made some tweets, basically saying, he truly believes, and I truly believe this too, that the 2020 election was tampered with. And I mean, it was tampered with, but define what tampering with means is really where we're at, right? Because I don't know, Right is Right, and let me ask you this, Doug and Right is Right, do you acknowledge that the 51 intelligence agents that came out and said Hunter Biden and his laptop, the laptop was Russian disinformation, was that tampering with the election in some way? I'm curious. Sorry to call you out, Doug. I appreciate the discourse, actually. So I'm curious, what are we defining as tampering? Now, is stuffing or harvesting ballots, that's tampering to some degree, especially it's just, almost anywhere. It was not tampered with. There was no evidence of any such doing. If there was evidence, why didn't anybody show it? I'm saying the report from the 51 intelligence agents. What do I have to rattle off the names of all 51 of them? The report that I'm referring to. They said Hunter Biden's laptop was disinformation. And basically, what we got from Hunter Biden and his laptop wasn't just, dirty pictures. We got evidence of peddling the Biden brand and influence in the U.S. government. So my question is that tampering? Because if you're saying, yes, actually, that was tampering, I do agree with that. Well, I'm curious. So here's the question. is, to what degree is Trump allowed to have an opinion about how to respond to that tampering? And to what degree does that maybe violate the Constitution? I'm not even exactly sure what the Truth Social says, but I think it was in the context of the election being tampered with. And how do you, because the thing is, after the election, you swear in a new president. I mean, what are you going to do? Overturn the election? It has to take like the hand of God to do something. So any suggestion that you make in response to the election was tampered with, and there's a guy in the White House who shouldn't be there, anything you suggest is basically gonna fly in the face of the Constitution. And I think that's where we're at. Happy Monday, Scott. I'm gonna turn up the volume on whoever we got in the mic, just to hear what he's saying a little bit.
It's within the context of being chairman of EEOC. It's within the context of general political philosophy. And
we can probably figure out where we're getting started again. Oh, I believe it. Right. I've been thinking about having something like that. Some element of that. I really just want to get Matt. I want to get Matt on the stream. Is he still in here? Yes. A nice family. Son Jamal. Oh, yeah. Well, let me say, Matt, your views are pretty hilarious. I haven't. Right is right. I haven't taken any call-ins yet, but it's definitely not beyond. I think it's fairly simple to take and put a phone number back here, right? Something like that. But even digitize it. I haven't thought much about it past that. I've seen other streams do it. And they did not edit this down for me.
Senator Kennedy has arrived in the room. He is expected to go up next for the questioning of the nominee.
There you go.
Very much, Mr. Chairman. First of all, Judge Thomas, I want to commend you for an extremely moving description about your early years, your relationship with your family, your grandfather, and really describing a situation which has existed for far too many people in our society. And I found it extremely moving, and a very fair characterization in terms of your own integrity and fairness. And I commend my colleague and friend John Danforth. I've had the good opportunity to serve in the Senate for many years, and I've heard many members of the Senate introduce nominees for various positions, and I've never heard one that has been more eloquent or heartfelt than Senator Danforth's statement. And for those of us who have respect for him and for his values, I want to say how much I certainly appreciated it. As you understand, we're questions of you or about your views of the Constitution and the role of government, and I'd like to, if I could, start out with the issue of the role of government in our society. You've, in several of your speeches and articles, you've taken a broad view of business rights, of an employer's interest in being free.
Well, Senator, with hold for a second. Would you close that door, please? Tell people in the hall to come in now or stay out for a while, okay? Because the Senator cannot be heard. Thank you very much.
Thank you, yes, Chair. Right. Well, in a number of speeches and articles, you've taken a broad view of business rights, of an employer's interest in being free of government regulation. If confirmed, you'll be called upon to interpret the federal, state, and local laws protecting employees and regulating workplaces. And if you were hostile to these efforts and construed them narrowly as a result, you could seriously undermine our efforts to correct unsafe and unhealthy conditions that endanger millions of working men and women across the country. And I'd like to ask you about some of your statements on this important issue. In 1987 interview with a publication called Reason, you questioned the need for many important federal agencies. You said, and I quote, why do you need a Department of Labor? Why do you need a Department of Agriculture? Why do you need a Department of Commerce? You can go down the whole list. You don't need any of them, really. You were quoted correctly, were you not?
Senator, I, again, don't know the context of that quote. I don't know what I said before or after. Of course, I think all of us would certainly be in favor of, and I certainly count myself among those Americans who are for safe working environments and who are strongly for protections from abuses and exploitation from individuals who have more clout and more power. I'm for safe working environment, and I'm for the standards that protect workers. And I'm certainly, as I've made clear during my tenure at EEOC, strongly in favor of laws that prevent employers from discriminating against individuals.
Well, I'll put the full interview in the record. You were asked about various departments and agencies and the necessity for your own agency, I believe, as a matter of fact, and in response to do you remember at all the interview, the research interview? I have it. I'll put it in the record. The inquirer said, I suspect that we might think that the EEOC ought not to exist. Why do you think that this agency should exist in a free society? Well, in a free, this is your answer. Free society, I don't think there'd be a need for it to exist. Had we lived up to our Constitution, had we lived up to the principles that we espouse, there would certainly be no need. There would have been no need. Unfortunately, the reality was that for politics reasons or whatever, there was a need to enforce anti-discrimination laws, or at least there was a perceived need to do that. Why do you need a Department of Labor? Why do you need a Department of Agriculture? Why do you need a Department of Commerce? You can go down the whole list. You don't need any of them.
From that quote, Senator, I think the point that I was trying to make, there are certain individuals who think you don't need any government involvement, who felt that EEOC should not exist, for example. Well, in a perfect world, you don't need EEOC, but this is not a perfect world. In a perfect world, you probably wouldn't need a Department of Labor or a Department of Agriculture.
Well, why,
this is not
if you take a Department of Labor with enforcement of, say, OSHA regulations, a Department of Agriculture trying to deal with food inspection, Department of Commerce trying to ensure that American workers are going to be competing with a fair playing field. I was just wondered, even in why you might suggest that those agencies, as well as others.
Well, let me explain, I think, the point that I was trying to make. I believe, and I would have to go back and look at the entire question, but the point is this. There are some individuals who say, well, we don't need any government. We don't need EEOC. Why should there be an EEOC? Well, if there were no discrimination in the world, I don't think you and I would think that there was a need for EEOC. The reality is, though, that there is discrimination in the world. You could ask rhetorically, what is the need for other departments if this were a perfect world? The answer is, this is not a perfect world. If this were a perfect world, you wouldn't have to enforce health and safety laws. But the answer is that there are some people who violate health and safety laws, and you and I think many others, think that people should be protected from those sorts of individuals.
Well, don't statements like these suggest a hostility on your part to attempts by government to help people that can't help
No,
themselves?
Senator, I think I was actually defending the effort in instances where there is a need for the government to participate and for the government to have a role. There were many individuals. I remember sitting down with an individual early in my tenure at EEOC, and his first words were to me in a very pleasant way but firm, you know, I don't think this agency should exist. But I spent a considerable amount of time defending the need for this agency and defending the need for a specific role of the government in certain areas.
Well,
and I think that was the point I was trying to make there.
Just to read that these final words of yours, after you said you don't need any of them, I think, though, if I had to look at the role of government and what it does in people's lives, I see the EEOC as having much more legitimacy than the others if properly run. Now you run the risk that the authority can be abused. When EEOC or any organization start dictating to people, I think they go far beyond anything that should be tolerated in this society. Well, now, in a speech at the Pacific Research Institute in 1987, you criticized entitlement programs. This is what you said. The attack on freedom and rights had to be accompanied by their redefinition. In the socialist view, the new freedom was thus only another name for the old demand for an equal distribution of wealth. The new freedom meant freedom from necessity, and it was a short road to what we call today entitlements. Before, a right meant the freedom to do something. Now a right has come to mean, at least in some, unfortunately, growing circles, the legal claim to receive and demand something. Which entitlements were you referring to as socialism? Social Security or Medicare, unemployment insurance, student
I don't
loan?
think I referred to any of them specifically, Senator. I think I was trying to make the distinction between what we traditionally consider rights and freedoms versus programs that are specifically implemented or initiated by the government. I don't think that my comment there was one where I was looking at a specific governmental program and saying that this is an entitlement program that I think is bad or good. I think there's a comparison, there's a debate, and I thought it was a vibrant debate about what our rights and what our freedoms were.
Well, what's your view about entitlements?
I think that I've said in speeches, and I think that it's appropriate. There are many of us. I think that I have said in speeches, and I think that programs, there are certain programs in our society that have helped. I remember visiting my mother in Fellwood Homes, which is a federal housing project in Savannah, Georgia. Fellwood Homes was seen as what? It was seen, we lived in a tenement, she moved to a lane, a dirt street, and a move up in the world, a stepping stone, was Fellwood Homes, before she could then move to something better. I thought that those programs were good. I think we all, though, in a pluralistic society are concerned that sometimes when we do something that we hope is good, that it may, on some occasions, have a negative impact. And I think that it's not illegitimate to say that some of these programs, or at least some of the ramifications, may not be what we expected, and some of the consequences may be unintended consequences. But I certainly believe that the efforts on behalf of providing public housing to my mother, or the efforts of providing relief to individuals who could not receive jobs, et cetera, in my neighborhood were very, very good efforts.
Well, of course, as you know, there are certain programs which are entitlements and other programs which are not, and I think all of us understand some various programs work well, others do not. And I'm sure we as an institution don't do as well as we should in sorting out the ones that do not. But entitlements have a special position. They certainly do from a budgetary position, and they've been selected by the Congress, basically in a bipartisan way, because they have a certain relevancy, because they have had an evaluation. And when you mention something like Social Security, student loan programs, various crop insurance programs, some of the other half a dozen or so, because there's only that many, some of the particular programs for children, those are considered entitlements. And I didn't know you're bunching those together as in the same, or within the same paragraph, as talking about the socialist view. The new freedom was that thus only another name for the old demand for equal distribution, effectively entitlements.
Well, certainly I, again, don't remember the full context of that, but let me just say this, Senator. I was not speaking in a budgetary sense or a more technical sense. I think I was comparing two views of what rights are today, and I thought it was, as I said, an important discussion and an important debate.
In 1988 article, you stated that, and I quote, "Our current explosion of rights, welfare rights, animal rights, children's rights, and so on, goes on to the point of trivializing them." Which children rights do you object to?
I guess I don't object to rights. The only point I was making, Senator, and it wasn't in any way undermining the need to be concerned about these problems in our society. I certainly have been involved with organizations to make sure that kids are not abused, and I certainly spend my time trying to make sure that kids are given guidance and help. I think that's very, very important in our society. But my point was that when we talk about rights that we consider basic or fundamental or freedoms, that when you begin to attach the word right to a particular effort or cause or program that you believe in, that then the notion of rights becomes one that's commonly used as opposed to reserved for these very, very important rights that we believe in. Again, that's not in any way saying that there is no problem, but simply saying that it becomes a common experience to simply declare a particular right.
Well, the reason I'm really questioning is this line of questioning is to get some kind of sense about your view about various statutes that will be approved by the Congress to address what the Congress believes are areas of need, and whether from these statements that it's fair to draw any implications of some hostility to statutes which would be drafted by the Congress to try and focus in the areas of particular needs or protections. For example, the OSHA for protecting the workplace, or whether it's the food inspections, or whether it is in terms of trade, or whether it is in terms of even parental leave, which you've expressed some degree of hostility to in your statements. The real question is whether we draw any conclusion as to the degree of hostility that you might have by yourself in interpreting statutes, given these kinds of statements, when perhaps there's an approach to trying to deal with these kinds of conditions that you may or may not agree with.
Well, Senator, I think that when one is in a policy-making function, just as if I were in this body, I could debate with you, and I think quite legitimately, about my concerns in particular areas. I think you have a sort of a role, or at least a part of your function would be an advocate for a particular point of view. But when you make a decision, when you write a statute, when this body deliberates and concludes, whether I agreed or not in a policy-making function, when I operate as a judge, or when I decide a case and look at it as a judge, I am no longer an advocate for that policy point of view. My job is to interpret your intent, not to second-guess your intent. It's not to second-guess what you think is the appropriate policy. It's not to second-guess whether or not you're right, not to second-guess whether I think it would be better to have 10 more rules as opposed to the 5 that you have, but simply to determine what you felt was right, what you felt was correct, and what your intent was, and to apply that. And that's the way I see my role now as a judge.
Well, it's helpful because many of the decisions are going to be made by the court over the period of these next years are going to reflect the basic tension that exists between an executive and a Congress in the development of legislation and what the court is going to say on many of these matters. It's increasingly the factor at the present time. And so your view about how you approach this is, I think, very important, and particularly in light of these earlier comments. Let me move to another subject area, and this is referring to an article about you in the Atlantic Monthly, 1987. You said that hiring disparities could be due to cultural differences between men and women. This is the article Question of Fairness by Juan Williams. That article states that you said that it could be that women are generally unprepared to do certain kinds of work by their own choice. It could be that women choose to have babies instead of going to medical school. Do you still think that that explains the underrepresentation of women in so many jobs in our economy today?
I think it's important to state this unequivocally, and I've said this unequivocally in speech after speech. There is discrimination. There is sex discrimination in our society. My only point in discussing statistics is that I don't think any of us can say that we have all the answers as to why there are statistical disparities. For example, if I sit here and I were to look at the statistics in this city, say with the example of number of blacks, I couldn't and compare the number of blacks that's on that side of the table, for example. I cannot automatically conclude that that is the result of discrimination. There could be other reasons that should be explored that aren't necessarily discriminatory reasons. I am not justifying discrimination, nor would I shy away from it. But when we use statistics, I think that we need to be careful with those disparities.
Very little I could differ with you in the comment, but I was really driving a different point, and that is whether you consider women are generally unprepared to do certain kinds of work by their own choice. It could be that women choose babies instead of going to medical school. Let me just move on to your comments about Thomas Sowell, an author whose work you respect and many of whose ideas you've stated that you agree with. Mr. Sowell wrote in a book called The Civil Rights Rhetoric, a Reality. You reviewed that book for the Lincoln Review in 1988 as part of a review of the works of Thomas Sowell. And in particular, you praised Mr. Sowell's discussion, chapter 5 of his book entitled A Special Case of Women, and you called it a much-needed antidote to cliches about women's earnings and professional status. Mr. Sowell explains that women are paid 59% of what men receive for the same work by saying that women are typically not educated as often in such highly paid fields as mathematics, science, and engineering, nor attracted to physically taxing and well-paid fields such as construction work, lumberjacking, and coal mining, and the like. As a matter of fact, there were no women employed in the coal mine industry in 1973. 1980, after the federal government had begun an effort to enforce anti-discrimination laws, that 3,300 women working in coal mines. Does that surprise you at all?
If there's discrimination, it doesn't surprise me. And there were lots of places, I think, in our society. You know, I used to, when I can remember in my own classrooms looking around and realizing that 7 or 8 of the top 10 students in my classroom in grammar school were the smartest students, and wondering at that age, if 8 of 10 of them are the brightest, then why aren't there women doctors and why aren't there women lawyers? But the point that I was making with respect to Professor Sowell, again a statistical one, there is a difference between the problem that, say, a 16-year-old or 18-year-old minority kid, female in this city or in Savannah or across the country, who's who's dropped out of high school. There's a difference between that, the problems of that child or that student, and then there is for someone who has a PhD or someone who has a college degree. And I thought that it would be more appropriate, again, referring back to the programs that you talked about, that we talked about earlier, in looking at how to solve these problems, that you disaggregate the problems and you be more specifics instead of lumping it all into one set of statistics.
Mr. Sowell goes on to suggest that employers are justified in believing that married women are less valuable as employees than married men. He says that if a woman is not willing to work overtime as often as some other workers or needs more time off for personal emergencies, then they may make her less valuable as an employee or less promotable to jobs with heavier responsibilities. He says that physical consequences of pregnancy, childbirth alone, are enough to limit a woman's economic option. And then he reaches some troubling conclusions about women in the workplace based on stereotyped gender roles. Yet you called those descriptions of women workers a much-needed antidote to cliches. Aren't those views the very cliches that women have been trying to escape from so long?
Senator, I think that that someone like a Tom Sowell is certainly one who is good at engaging a debate. And I think it's important that there be individuals who look at statistics in his way. Well, I did not indicate that, first of all, that I agreed with his conclusions, but I think this is an important point. I had, during my tenure, I think the majority of the members of my own personal staff and were women. And the conclusion, for example, about married women, I found certainly not supported by my experience with married women on my staff. That was not the point. The point is that I think sometimes that we can be involved in debate and make generalizations, and it's always good to have someone who has a different point of view and has some facts to debate that.
Well, the reason I raise this is because with regards to this particular description of women, you described that chapter as a much-needed antidote to cliches, and I think I think many women would read his description, particularly in that chapter, as being really a description of the stereotype, attitude, which has really kept them back in too many instances. I'm sure you're commendable for what you've done, and that's a powerful factor in relationship, obviously, with other statements or speeches. But nonetheless, that chapter really stands out, and that's why I wanted to bring this up.
Well, I think that, again, Senator, I think it's important that in our society and as a policymaker that you have debate. I don't think that Professor Sowell or others are in any way sexist or in any way people who would discriminate. I made it a point. It was very important to me during my tenure at EEOC, and it's been very important to me during my life to make sure that these arbitrary stereotypes, that these arbitrary discriminatory barriers were knocked down. And I think you can simply look at my record in promoting women to the senior executive service. I think it's second to none in the federal government. Similarly, with respect to my personal staff. I think it is important. I do think that discrimination exists, and I think it needs to be eradicated. But at the same time, when we do have approaches in our society, I think that reasonable people can disagree, and reasonable people of goodwill can disagree without being characterized in a negative way.
Okay, if just in the final part of my questioning, I'd like to come back to just an area that was raised by Chairman Biden in the concluding part of his questions, and that was with regard to the Lehrman essay. And you, in the speech in '87, you called why black Americans should look to conservative policies. You spoke about natural law. You said, and I quote, Heritage Foundation Trust Lou Lehrman recent essay in American Spectator on the Declaration of Independence and the meaning of the right to life is a splendid example of applying natural law. And the title of the Lehrman article you endorsed is The Declaration of Independence and the Right to Life. One leads unmistakably from the other. The article makes only one argument, and it's about only one subject, that natural law protects the right to life, and that as a result the Constitution must be interpreted to protect the right to life. So Lehrman's basic position in that is that abortion violates the constitutional right to life. And he argues that when the Supreme Court decided Roe v. Wade, it simply conjured up a right of abortion. And he calls it a spurious right born exclusively of judicial supremacy with not a single trace of lawful authority. He also draws a parallel between those who support abortion and those who supported slavery. He says the decision to protect a woman's right to abortion has resulted in a Holocaust. These extreme statements, perhaps about in terms of whatever about a woman's right to choose were all expressed in that article, and you called that article splendid. Is that correct?
Senator, again, I did not endorse the article, but I'd like to make this point, and it's very important, and it's perhaps one that was missed earlier. My interest toward the end of the Reagan administration was an important interest to me, and that was that I had spent almost a decade of my life battling with individuals who were conservative, and I felt that they should not be antagonistic to civil rights, and I felt that in fact they should be very aggressive on civil rights. In exploring on a part-time basis and during my busy work day a unifying theme on civil rights and on the issue of race, I was looking for a way to unify and find a way to talk about slavery and civil rights, the way that the abolitionists used, the very same approach that was used and offered in the Brown v. Board of Education brief, authored among others by my predecessor, by Justice R. Marshall, whose seat I've nominated to fill. My point was that I figured, or that I concluded, that conservatives would be skeptical about the notion of natural law, but one of their own had endorsed it. And I simply wanted to give some authenticity to my approach so that I could then move on and get them to consider being more aggressive on the issue of civil rights. That was very, very important to me.
Well, have you ever publicly stated that you disagree with the article?
I have never been called on. It's never been raised as an issue. It was considered, I think, by many as a throwaway line. I saw it as that, as something to consider to convince my audience, and it's never really come up. As I indicated, I don't think that you can use natural law as a basis for constitutional adjudication, except to the extent that it is the background of in our Declaration. It is a part of the history and tradition of our country, and it's certainly something that informed some of the early litigation, I guess, with respect to the 14th Amendment. But it's certainly something that has informed our Constitution, but I don't think that it has an appropriate role directly in constitutional adjudication.
Well, do you disagree with the article now?
I do disagree with the article, and I did not endorse it before. My point was simply, and I think it was an important point, that I endorse natural law. And that I use natural law to make the point that the conservatives should aggressively enforce civil rights.
Well, do I understand now you do disagree with the article?
I disagree in the manner that he used it, yes. I disagree with the article, yes.
Okay. Can you elaborate?
Well, to the extent that he uses natural law to make a constitutional adjudication in that sense, or to provide a moral code of some sort, I disagree with it.
But with regards to the other features of the article?
I don't know all the other features of the article. My interest was a very single-minded interest, Senator, and that was in trying to convince a conservative audience in the Lou Lehrman Auditorium of the Heritage Foundation with a concept that Lou Lehrman adopted to make my point. Right. And it was an important point to me. I did not endorse, nor do I now endorse, other portions of his article.
Did you mentioned in that speech, did you say anything else about Lou Lehrman? I mean, he's a trustee of the Heritage Foundation, of the work that he's done. Did you say anything else other than endorsing this article? I mean, most of us in these kinds of circumstances, perhaps are looking about gilding the lily or so, but I mean, there are different ways of doing it. I'm just asking whether you talked about his work as a trustee of the Heritage Foundation or other work that he's done, or was the only reference to Mr. Lehrman about this article?
His use of natural law was the only reference. And again, Senator, this has not been something that has come up in a way that required explication. The important point for me was a very simple point, and that was that I was attempting to convince conservatives, individuals whom I thought would be skeptical about the notion of natural law and skeptical about aggressive enforcement of civil rights the way that I believe that civil rights should be enforced, that here was a basis on which they could be aggressive. And I thought it was an important speech, and I saw it, the manner in which it was quoted prior to my nomination to this court was one in which I was criticizing the administration and criticizing conservatives.
Well, I didn't find any reference to civil rights in the Lehrman article.
No, but throughout my speech there is reference.
I've read that. Just finally, did you agree with any parts of the article, the Lehrman article?
My only interest, again, was in the notion that he used natural law. I don't think that natural law can be used to adjudicate the issue that he adjudicated.
Time is up, Mr. Chairman. Thank you.
Thank you very much, Senator Hatch, and then we will end today's hearing.
Thank you, Mr. Chairman. In all due respect, let me just start with the chairman's excerpt that he cited to you earlier. That excerpt from the Pacific Research Institute speech is, in my view, completely out of context. Let me just read it to you. Quote, "I find attractive the arguments of scholars such as Stephen Macedo, who defend an activist Supreme Court which would strike down laws restricting property rights. But the libertarian argument overlooks," you immediately take on that statement, "but the libertarian argument overlooks the place of the Supreme Court in a scheme of separation of powers. One does not strengthen self-government and the rule of law by having the non-democratic branch of the government make policy." Now, in all honesty, I would ask that the entire speech be placed in the record, and I would also suggest that we not pluck a sentence out of context. None of us should do that. From 138 speeches that you gave, gee, I'd hate to remember all the speeches I gave in any given period of time. And I think we ought to have it all in context, and you ought to be given a copy of it so that you can refer to the actual language. I think that's the only fair way to do it. The committee has obtained...
Before the hearing even began, on Friday, I told the witness that the first thing I would ask him about was Macedo. I specifically told him that, so he understood that even back then, which is unusual for anybody to tell in a hearing exactly what we're going to talk about first. So
I'm not suggesting the chairman's unfair. I'm saying that the process is unfair if we don't do at least this. When we want to quote a line out of context, I'm suggesting from here on in, let's give the judge a copy of the speech and refer to the line that you're quoting on, because this one was clearly out of context, and clearly he wasn't endorsing the Macedo definition of an activist Supreme Court. I mean, it's very clear to anybody who reads it. This committee's obtained over 30,000 pages of documents or material from this nominee, and I think if he's asked about one of his writings, he at least ought to be able to see it in front of him, and I would suggest that we follow that procedure. I think it would be good. And now, Judge, let me just ask you this. Will any of the writings or speeches cited today affect you in your role as a judge or as a justice in this particular case? Or will you rely on the actual text of the law, the legislative history, prior case law, etc.?
Senator, as I noted, my interest particularly in the area of natural rights, was as a part-time political theorist at EEOC, who was looking for a way to unify and to strengthen the whole effort to enforce our civil rights laws, as well as questions, to answer questions about slavery and to answer questions about people like my grandfather being denied opportunities. Those were important questions for me. When one becomes a judge, and I think I alluded to this in my confirmation hearing for the Court of Appeals, there are approaches to adjudicating cases and to understanding statutes, to analyzing statutes and determining meanings in statutes or your intent in statutes. as well as constitutional adjudication. And I do not see how my writings in a policy context, I don't see that they will affect anything that I do on the Supreme Court. As I noted, that the whole notion of natural law is, as our founders believe it, is a background of our regime. And to the extent that it's used at all, it is an understanding of the way that they looked at our regime and the way that they, in the Declaration of Independence, felt that our country should operate. And of course that then is translated into provisions that they draft for the Constitution itself. It informs us as to the value that they put on individual freedom, for example. I think that that is important, but that does not play a direct role in adjudicating cases on a constitutional basis.
Well, I agree with that. In the article cited by Senator Kennedy, it was in Reason, November 1987. Reason says, this was an interview, off-the-cuff interview, I take it. Reason says, I suspect that he might think that the EEOC ought not to exist, talking about Tom Sowell. Why do you think that this agency should exist in a free society? Well, your answer was, well, in a free society. Today you said, well, in a perfect society. I think that's what you meant by that. Well, in a free or perfect society, I don't think there would be a need for it to exist. Had we lived up to our Constitution, had we lived up to the principles that we espouse, there would certainly be no need. There would have been no need for manumission either. Unfortunately, the reality was that, for political reasons or whatever, there was a need to enforce anti-discrimination laws, or at least there was a perceived need to do that. Why do you need a Department of Labor? Why do you need a Department of Agriculture? Why do you need a Department of Commerce? Those appear to me to be rhetorical questions in light of the point you're making. In a perfect world, you don't need them. But here was discrimination, and we needed to enforce anti-discrimination laws. You can go down the whole list, you say. You don't need any of them, really. But what you meant was, and it's apparent if you read this carefully, in a perfect world. You go on to say, I think, though, if I had to look at the role of government and what it does in people's lives, I see the EEOC as having much more legitimacy than the others, if properly run. That's a day-by-day, hands-on, person-to-person agency that's dealing with the most common problems in employment law and in discrimination and in opportunity. Isn't that correct? Well, here's what you say. Now, if you run the risk that the authority can be abused, when EEOC or any organization starts dictating to people, I think they go far beyond anything that should be tolerated in this society. That's a far cry from what was implied in the questions to you. You go on to say other things that I think you make pretty clear. Still, it was an off-the-cuff interview with a publishing group. And frankly, I think it's pretty clear that you weren't arguing we should do away with all these agencies unless we had a perfect world. Is that fair? Is that a fair summary of that?
That's the point that in that interview I was trying to make. The question, and that's Reason magazine, if I remember correctly, is a libertarian magazine.
Yeah.
And some libertarians believe that there should be no organizations and no governmental agencies such as EEOC. So the question then becomes, how do you justify, if you're for the individual, how do you justify a governmental agency that interferes in relationships, the employment relationship between individuals? And the response is, well, if this were a perfect world, you might be right, but this is not a perfect world. And if there's a justification for any kind of an agency in our government, and there are many, then EEOC is at the top of that list.
Well, I suspect you're going to be criticized for some of your tenure at the EEOC. I cited the Washington Post praise of you. I cited the U.S. News and World Report praise of you. And as former chairman of the Labor Committee and currently ranking member, we've had a lot to do with the EEOC. And I have to tell you, you did a good job running that agency. Was it perfect? No, but you did a good job. And frankly, you took it seriously, and you brought more cases than any other EEOC chairman in history, and you recovered over $1 billion in some of those cases. You go on and on. Let me tell me generally your reaction to these comments, Judge. Natural law is not a theory of legal interpretation, according to Professor Robert George of Princeton University, who is a lawyer and holds a doctorate in philosophy from Oxford University. Rather, he goes on to say, it is a theory of law that holds that there are true standards or principles of morality that human beings are bound in reason to respect, and that among these are norms of justice and human rights that may not be sacrificed for the sake of social utility. Both liberals and conservatives share a belief in fundamental principles of justice and right, however much they disagree about the exact content and implications of some of these principles. The relevance of natural law to judging. It is that out of respect for the rule of law, judges are obliged to recognize the limits of their own authority. The scope of a judge's authority is settled not by natural law, but the constitutional allocation of political authority among the judicial and other branches of government. Now, as Professor George has written, belief in natural law is perfectly consistent with fidelity to the Constitution as the supreme law of the land and with the commitment to judicial restraint. Now, whatever may be your views of the rights and wrongs of various social issues as a matter of natural law, it seems to me your commitment to natural law and natural rights neither permits you nor requires you to treat the Constitution as a vehicle for imposing those ideas on the rest of the country. Do you agree basically with that statement?
Senator, that's, I think, in part the point that I was attempting to make. My interest, for example, was in the fact that in our country, you had a stated ideal in the Declaration. All men are created equal.
Now, natural law means there shouldn't be slaves, right?
That's the point that the next step, that if that is true, then how can one person own another person? And yet, you had slavery existing at the same time the Declaration existed. In order to change that constitutionally, not as a matter of principle in our regime, but constitutionally, you needed an amendment to the Constitution. And I indicated that there is a difference between the ideal and the Constitution itself. With respect to constitutional adjudication, I don't think that there is a direct role for natural law in constitutional adjudication. It is a part of our history and tradition. It is a part of our background in our country. It is a belief that a number of our drafters held. It is in our Declaration, and as I mentioned before, it is prominent in the brief filed by the NAACP and Brown v. Board of Education to show the ideals of this country. But it's even there as an appendix. I think it's listed as a political philosophy section. I don't know, I can't remember whether it was advocated as a way to adjudicate, but my point is that it is not a method of constitutional adjudication. When I was speaking as chairman of EEOC, again, I was a policymaker. I was not a litigator, and I was not a constitutional law professor.
And that's a good distinction, by the way.
Well, it was an important one for me, and it's an important one for me now. When one is a judge, one, from my standpoint, one does not go into one's own personal philosophies and apply those personal philosophies in one's effort to adjudicate cases. And I think that there are principles, that there are traditional approaches that have been used, and I have confined myself and would confine myself to that.
And when you're talking about natural law, you're talking about equality.
That all men are created equal, that's a basic.
Right, and you're taking that from the Declaration of Independence.
That's right.
And you're saying that that's why we needed the 13th, 14th, and 15th Amendments.
That was the most apparent and grossest contradiction in our society, that you had the Declaration declaring all of us to be equal, and yet the existence of the coexistence with that of slavery.
Well, I find it to be interesting because Judge Bork was criticized because he didn't particularly endorse the principle of natural law, and now you're being criticized because you do. And frankly, it's a double standard. And I might add, by this same committee. What I interpret you to be saying, and maybe I'm wrong, you correct me if I'm wrong, is that when it comes to natural law and the Constitution takes preeminence.
The Constitution is our law. It's the law of our land. The natural law philosophy is a political theory. It was my interest was political theory. It was not constitutional law.
And so when you become a justice on the United States Supreme Court, and I believe you will, you intend to uphold the Constitution of the United States, is that correct?
With every fiber in my body.
Above anything else?
My job is to uphold the Constitution of the United States, not personal philosophy or political theories.
Well, I think that's a pretty good way of putting it. Let me just, some have criticized natural law as being outside the mainstream. I've seen articles by some of our eminent law professors in this country, at least one in particular that I can see. If natural law is outside the mainstream, then so is the Declaration of Independence. And that's the point you're making, it seems to me. As Professor Robert George of Princeton University observed, he said, if you believe that slavery was inherently unjust and should have been abolished, you believe in natural law of some sort. Throughout our American history, many of our greatest leaders, Thomas Jefferson, Abraham Lincoln, Martin Luther King Jr., they've all invoked natural law in their struggles against injustices of their times. Now, I think you're being accused of, if you believe in natural law, then that means that that would make you a conservative judicial activist. Now, I have to tell you, as much as I care for you, and as much as I know you and believe in you, if you're going to go on the bench to be a conservative judicial activist, I'm going to be against you as much as if you were a liberal judicial activist, because I don't think that's the purpose of that role on the court.
Senator, I think that was the point, and I have to go back and read the speech involved, but that was the point of the criticism of Macedo, that he indeed was an activist, and I think there was some debate about that. And I don't think the role of the court is to have an agenda to say, for example, that you believe the court should change the face of the earth. That's not the court's role. And there's some individuals who think, for example, as the chairman mentioned earlier, that the whole landscape with respect to economic rights should be changed. And I criticize that.
Well, as I understand it, both in our personal discussions and also in reading some of the things that you've said and written, you recognize that the natural law principles of the Declaration of Independence as reflected in the written Constitution, that they constrain both legislative majorities and the courts. Am I correct on that?
That's correct.
Moreover, many who criticize you today for acknowledging the existence of natural law were the most vociferous critics of Judge Bork 4 years ago for not acknowledging the existence of natural law. I just want to make that point. And by endorsing Louis Lehrman's article in the American Spectator, some say that you have signaled that you would vote to overturn Roe versus Wade. Well, I think you've made it pretty clear. You were complimenting Lehrman as trustee of the Heritage Foundation in the Lehrman Hall when you made that particular remark in a 9 single-spaced page talk that you gave. And as Senator Danforth has said, to say that Judge Thomas thereby adopted or endorsed Louis Lehrman's entire article is like suggesting that any of our references to a, quote, distinguished colleague, unquote, in the Senate is a full-fledged endorsement of everything that distinguished colleague, quote, distinguished colleague, has ever said. Now, that's ridiculous. And I personally think the implication's ridiculous as well. But let me just ask you the question. Have you made up your mind, Judge Thomas, on how you will vote when abortion issues are before the court as a justice on the court?
Senator, there is a lesson that I think we all learn when we become judges. And I think it happens to you after you've had your first case, that you walk in sometimes even after you've read the briefs and you think you might have an answer. And you go to oral argument and after oral arguments, you think you might have an answer.
That's right.
And after you sit down and you attempt to write the opinion, you thought you had an answer, and you change your mind. I think it's inappropriate for any judge who's worth his or her salt to prejudge any issue, or to sit on a case in which he or she has such strong views that he or she cannot be impartial. And to think that as a judge that you are infallible, I think totally undermines the process. You have to sit, you have to listen, you have to hear the arguments, you have to allow the adversarial process to think, you have to be open, and you have to be willing to work through the problem. I don't sit on any issues, on any cases that I have prejudged. I think that it would totally undermine and compromise my capacity as a judge.
I think that says it all, but let me just say this. I've been interested in some of these questions about substantive due process issues. As you know, the first substantive due process case was the Dred Scott case in 1857. That's where the Supreme Court held that the, quote, liberty clause, unquote, of the due process clause prevented Congress from forbidding slavery in the territories. Now, later in the 19th century and earlier 20th century, the Supreme Court employed substantive due process in Lochner v. New York. That's the case that came up earlier, to strike down a law that limited the numbers of hours that the bakery workers could work in a week. The federal government passed a law, and Lochner struck it down. There were other substantive due process cases up until the 1930s. And all of those struck down efforts by the states to regulate the workplace and the economy. And substantive due process was basically dormant from that time until the early 1960s, when the court, of course, began to use substantive due process to achieve liberal results. Or should I say liberal social policy results. Now that was all right. The other was wrong. I'm telling you, both of them are wrong. The fact of the matter is that nobody in his right mind believes that you're going to go strike down all of the social policy results that the Congress has passed, including OSHA, food safety laws, child care legislation, welfare laws, fair housing laws, low-income housing, and so forth. Is there even any shred of evidence or any shred of thought that you would be the type of judge that would be a substantive due process judicial activist that would take us back to the Lochner days?
To my way of thinking, Senator, there isn't. I think that the post-Lochner era cases were correct. I think that the court determined correctly that it was the role of Congress, it was the role of the legislature to make those very, very difficult decisions and complex decisions about health and safety and work standards, work hours, wage and hour decisions, and that the court did not serve the role as the super legislature to second guess the legislature. I think that those post-Lochner era cases were correctly decided, and I see no reason why those cases and that line of cases should have been or should be revisited.
Well, I agree with you. I have to note that it's somewhat ironic for my liberal colleagues to express concern that judges might start striking down economic regulations the way the liberal judges in some ways have invented criminal rights, struck down pornography restrictions, have run local high schools, and imposed taxes on cities and local governments. And you could go on with a judicially active set of courts that are doing all of these things today. And I too think that it would be wrong for judges to strike down economic regulation, just like you do. But what the liberals really ought to understand is that no one is safe when judges depart from the text of the written Constitution. And that's what's been happening from time to time. What we need are judges that won't make up the law in order to institutionalize their own social policy ideas or to impose their own values, liberal or conservative, on the American people. You know, I think the people can choose between liberal and conservative policies, but they should choose between them where they ought to choose between them, and that's in the elective process. That's what we're here for. They can choose by voting for whoever they want to in the elective process to make these laws, not judges on the bench. And that's what really is involved in a lot of this. Well, I could go on and on. I notice that everybody's probably pretty tired by now, but let me just say this. In fulfillment of your duties as a justice on the Supreme Court, are you going to be guided by Stephen Macedo and his ideas?
Absolutely not.
I didn't think
Senator.
so, and I don't think anybody else thought so. Do you intend to elevate property rights over individual rights and liberties, as was done in the early part of this century under the Lochner case and a whole progeny of cases like that?
I certainly had no intention of doing that, Senator. The court has attempted to approach rights such as on the economic decisions of the legislature, the classifications according to race, et cetera, in a way that I think is appropriate. I mean, it attempts to accord a value to these. The point that I was making is that the notion of property is in the Constitution. That in no way says how those cases should be adjudicated.
Well, you know, in those days, they elevated the so-called right of contract above the individual rights of individual human beings. And the right of contract took precedence over individual rights and freedoms, where the right of government to ease the burdens and the pains and the difficulties of the working class and the poor through health and welfare programs, wage and hour legislation, and other matters that they chose to do. The court at that time said that that was all outweighed by the right of contract. Well, I don't know of anybody that wants to go back to those days. Now, there may be some can misconstrue Epstein to believe that that's what he wants to do. I don't believe he wants to do that. But to make a long story short, Judge Thomas, I personally am very proud of your nomination. And I believe that you'll bring a dimension to this court that really hasn't been there before. Because I don't think you're going to be characterized in any particular pocket of anybody. And I know you well enough to know that you're fiercely independent and that you'll do what you believe is right within the Constitution. And I believe we've covered this principle of natural law, at least as much as we could here today. But I want to commend you for this opportunity. A lot of us intend to see that you have this opportunity, and I sure wish you the best in being able to serve on that court and to do it in the best interests of all Americans and in the right way and within the confines of the Constitution and in the way that I think you've been chatting with us today. So I commend you for what you've said, and I hope we can enjoy the rest of your testimony tomorrow. Thank you, Mr. Chairman.
Thank you. Let me conclude today by pointing out one thing. No one, notwithstanding my distinguished friend thus far that I know of, has criticized your view on natural law or whether or not natural law is bad. We're just trying to find out if you have a view on natural law and what it is. For the record, no one is criticizing your view. Professor Bork criticizes natural law. I do not. No one's criticized your view. We're just going to try to find out what it is. Now, with that, the hearing is adjourned until tomorrow at 10 o'clock.
All right. I mean, anybody is welcome to subscribe, right is right. Oh, you mean to my channel? Hi. So that was an interesting hearing. Natural law, as I had mentioned, had come up a lot, which is, you know, the idea some laws are, you know, come down from God and that they trump everything on earth, right? And that's kind of, you hear that, the natural man argument. If you've ever seen these funny guys, sometimes they look like woodsmen come to court, and there's like a meme, the natural man meme. But you know, the point I think the senators were trying to make is, what are you going to apply as a judge, natural law or the Constitution? And Clarence Thomas unequivocally, stated the Constitution is the law of the land. I think he probably made some comments, and later in life he even talked about, I wasn't expecting this whole thing to be about natural law. It kind of stole the show in a way. So, Alex, that's really funny. And so what else came up? Post-Lochner era decisions, which was, I think, there was a case in New York. New York had decided to regulate the hours a baker could work, and so I think that was seen as an overreach, and they asked about that. They also asked about evidence, whether it could be cured through a good faith discovery after, let's say, it was discovered maybe inappropriately. Fruit of the poisonous tree is the doctrine that you call it, right? When, let's say, you find something through a search that maybe you didn't have a warrant for, but you later obtained the warrant and would have discovered it, that could be a good faith discovery. Stuff like that. It's not the same everywhere, but I want to make sure that I did not. The judicial philosophy of the Lochner era, the Lochner decision, is emblematic of the broader era in American constitutional law, where the Supreme Court often struck down economic regulations on the grounds that they violated freedom of contract and other civil liberties. The legacy is the Lochner decision, and the era it represents remain a pinpoint of contention constitutional law decisions. Some view the decision as a necessary protection of individual liberties, while others see it as a problematic example of judiciary undermining democratic governance. I don't know. I'm pretty sure it was an overreach. No. Oh, it was an interesting chat today. I didn't dislike it. It went to different places. If you're just watching, the chat, we talked about a lot of issues that necessarily didn't have anything to do with this hearing, but maybe today it's more of an issue. We did talk about drag story hour and some other. I mean, that was the main one that came up, and I'll have to go back and dig and see what the heck happened. How did we stray so far from Justice Thomas and his confirmation? I don't know. But it was fun, and there's more to this hearing, right? There was more days of this. I think this is the first round of questioning, maybe. There's going to be more coming. Tonight, we will be covering the Elon Musk and Donald Trump hearing on X, which Donald Trump will be hosting. He made a brief comeback on X to post his mugshot, and I think it's been radio silence ever since then. So it should be interesting. Interesting hearing, decorum. I think that was one thing that people said. There seemed to be decorum back then. No, DJ spoke. What did come up in this chat too was this is a funny thing that we all forget. First of all, Hunter Biden was literally in the Naval Reserves for less than a year and got kicked out because he tested positive for cocaine. And they've found cocaine in the White House, after his visits. How does Trump and Trump Jr.? What are we even talking about? What switch up? What switch up are we? Okay, wait, I got to go back a little bit. Interesting that the last segment they talked about how no one thinks Thomas is going to be a substantive due process advocate and try to overturn 60s era civil rights. Yeah, well, it is interesting how things kind of, coalesce, come together, after decades and decades of. Yeah, I mean, listen, people thought that for a very long time. I think I probably thought that it was settled constitutional doctrine, up until recent. I didn't know it was still on the table. Before I went, yeah, did not know that was on the table. Everybody, yes, we'll see you later. A good place to wrap it up. Be well. Knowledge is power. Subscribe for more. We do cover hearings that are more current if you're new. But right now, Congress is in recess until about Labor Day. So we're going back and just, I want to follow the will of the chat. I put up polls to see where, we want to go next. It looks like we are going to do the Anita Hill hearings, which follow Justice Thomas's hearings, and then they pertain to it. And then maybe we'll do Scalia later. So that is the plan. Tonight, Trump and Elon, Tune in. I'll see you soon. Be well. That was fun.